Oh, this is the new one. This is a new one.
Yeah.
Oh, it's the violation?
You're charged with failure to complete the economic crime prevention program with Class A Training Center. That's count one. Do you understand the charge? Are you tired?
No.
Okay, I just wanted to make sure. Count two, that you failed to pay your fines and costs as ordered. Do you understand the charge?
Yes.
Count three, you failed to provide proof of completing 32 hours of community service by January 31 of 26. Do you understand the charge?
Yes.
If you plead guilty, if you're found guilty, that would be three more technical violations. Your probation could be revoked. You could be incarcerated for 90 days. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights, revocation, and probation form?
Yes, I do.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to provide you with one at public expense if you would like one. Would you like a lawyer to represent you? I'm going to ask you how you plead now. It's count one that you failed to attend the economic crime program with Class A Training Center. How do you plead?
Yes.
Did you fail to attend that program?
Yes, I did.
Count two that you failed to pay your fines and costs as ordered by January 31 of 26. How do you plead?
Yes.
You failed to pay your fines and costs as ordered by January 31 of 26. I'm asking, did you fail to pay all of your fines as you were ordered to pay?
Yes, yes,
Okay, but you failed to pay your fines and costs as ordered, correct?
yes.
Count three that you failed to provide proof of completing 32 hours of community service by January 31 of 26. How do you plead?
Yes.
Did you fail to provide proof of completing your community service by that date?
Oh, yes, I didn't turn it in by the day.
Anybody forced you to plead guilty?
Huh?
Anybody forced you to plead guilty?
No.
I'll accept your plea. I was probably too nice. I'll accept your plea as to all three counts.
I could pay the fines today and I got the community service paid that I didn't turn it in on time, but it was completed before the 31st.
You're not taking me very serious.
No, it was done. It was done.
Listen to what I'm telling you. You were in here on violations on December 17 of 25.
Yeah.
I did nothing. I didn't assess any costs. You had a failure to report, failure to complete community service. I told you to complete your community service and provide proof by January 31, pay $200 by December 23 of 25, the rest by January 31 of 26. And I told you again, if you didn't have the money to call the court, we'd go on Zoom, I'd give you an extension. None of that happened.
Okay, I do have a lot going on. My daughter's still in the hospital, so that's why this wasn't sent in. And the day I got a bill, I had to go straight to the hospital, stay there with my daughter for about 2 weeks.
For 2 weeks?
She's been here since December.
Is she still in?
Yes.
She's been there for 2 months?
No, a year and months. Like last December.
Well, December of 25, right?
December.
She's been in the hospital for 14 months?
Yes.
I don't remember us talking about this.
I didn't talk about it.
Your name?
Jessica O'Donnell. We did.
Remind me.
Yeah, her daughter has been in the hospital. She reminded you the last time that our hearing, and she's been in the hospital for over a year now. She did provide proof of the community service today. And based on the letter, it was completed prior to the due date, but she did turn it in until today. But those hours are now completed and confirmed.
Okay. What about the economic crime program?
That class is not in.
She did everything.
She did everything but the class at this point. She said that she has the money to pay today for her balance. Otherwise, though, the community service is done. The only thing left is the class. Her case was taken under the 771 delayed sentencing status. She's set for prosecutor review next week, February 19th.
Extend the training, the program won't be done.
No, it will not. I don't know when the next class is offered. I know the last one was January 18th and she didn't attend that.
I placed her on probation on August the 28th, so she should be coming off February 28th, true?
Correct.
So I'm gonna extend probation for 2 months until April 28th of 26. There's additional costs of $50, additional probation fees of $40. Heather, I'm gonna need a new review hearing date sometime before that. and you have to make sure you complete the Class A training center, okay? I don't remember talking about your daughter, so I didn't make any notes on it. I don't know why. Complete the program at Class A, and why don't you give me a date, Heather, like in, let's see, we're already mid-February. Why don't you make it second
April,
week?
Judge, or,
Yeah, second week of April or so.
okay, we could do April 9th.
All right, we're gonna make it April 9th. Review hearing will be April 9th at 8:30, okay, ma'am? You're gonna pay all your fines now, right?
Yeah,
All right, I'll make a note. You're gonna pay all your fines costs now. Proof of completion of community service provided. I wish you well. If you do everything when you're supposed to, you're gonna end up with this case dismissed. It was taken under 771. You gotta have everything else done though, okay? April the 9th at 8:30 will be your review hearing date. I wish you well. You'll go down the hall, you'll get your dates, and we're all set.
Thank
Good luck. And good luck with your daughter. I'm sorry you're going through that. I don't.
you.
Lobenberg. Jarek. Jacob Robert Lobenberg. Is that you?
Exactly. My name's.
Oh, where's Lobenberg? Oh, I see. 260-647-525 A and B. Okay, this is Judge Hessen's, I'm just gonna send it over there for her, okay, Heather? I believe it has her name on it. Is Lobenberg her case?
What's the case number on that again, Judge?
They keep sending them in here, 260-647-525, 260-647-525 A and B.
Let me double check on that.
Taking that to Judge Hessen.
Yes, that is hers.
Zachary, okay, good enough. I'm gonna send it in there. Zachary Ryan Hines, 25G306737 A and B. All right. Where's your lawyer?
Not know.
Oh. Okay. Okay. Well, we're gonna have to wait for your lawyer. Okay, I'll pass the case. You can relax. I didn't. Shoshana, Rochelle, Curtis, 26T647-504 A and B. Could I have Zuko seated at the table here, my right, your left? And you can come up here, Ms. Curtis. Your name? Nice and loud for me. You're charged with driving on a suspended and defective equipment. You have the right to an attorney. If you want one, I will give you one. Would you like a lawyer?
No.
I'll arraign you and then I'll send you to the prosecutor. I'm gonna need that one sentencing with Mr. Gamber. You're charged with
Is this Miss Curtis up here? Tashada Curtis?
What's
Is that
that?
who you- Is this Tashada Curtis? I'm sorry, that you have at the podium?
Yeah.
She has 2 warrants that we're working on right now also. And I believe it does look like though they are Judge Hessen, so I'm not sure if you just want to send her over there or when we're done with them. But just to give you a heads up.
All right, thank you. Ms. Curtis, you're charged with operating a motor vehicle on January 18 of 26 in the city of Trenton on Fortner West at 1:16 in the morning. They think you had defective equipment and a suspended license. That is a misdemeanor driving on a suspended, punishable by up to $500 in fines, 93 days jail costs, or all of those penalties. Do you understand that? Nice and loud.
Yeah,
Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. Do you understand that? Yep. You still wish to waive your right to a lawyer? I'll enter a not guilty plea. You got to show up in court. Why? When was she scheduled for court that she failed to appear on?
October 12th of 2022.
Oh, geez, I don't want to rush you here. What are you doing?
Bill Court, where?
Here, this place. You were supposed to be here in October of 22. Well, don't sound so aloof about it, okay? You're not endearing yourself to any judge when you pull that kind of nonsense. You're gonna be arraigned on those warrants next door. $500 personal bond. You're lucky you're getting a personal bond. You work? What are you acting like this for? Like I don't recall, like it's not a big deal. Like I forgot to pay my water bill that was $3.13. Young lady, don't play games. Judges don't like games. You want to play games? Go to the store, buy Scramble or Trouble or Monopoly or whatever else. Don't play games in here. You got it? Good. You'll go meet with the prosecutor. Either way, you'll come back in front of me, and then you have to go next door to Judge Hessen, and she will arraign you on those charges when they cancel the warrants. Good luck. Zuko. Either way, you're coming back in front of me, young lady. Joseph William Zuko, 26G306819A. And B, your name? You're charged with driving while license expired. You're also charged with no proof of insurance. You have the right to a lawyer. Do you want one? It is alleged that on January 7 of 26 that you did operate a motor vehicle on Middle Gibraltar near Jefferson in Gibraltar at 9:25 p.m. They think you had an expired license. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs are all those in 2 points. Do you understand that? You're also in court on a civil infraction charge of no proof of insurance. That's 0 points. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights. We're not going to have a trial. You understand that? All right. You still wish to waive your right to a lawyer? Enter a not guilty plea, $100 personal bond. You cannot leave the state without consent. You can't violate a law. You must appear in the court as directed. Why weren't you here on January 29th?
I bet out there at court on Friday. I was on the 30th.
Did you show up on the 30th?
No, I called up you.
What'd you call up here on what day?
Called on the 30th.
For what? Why'd you call if you thought you had court? Why don't you just come up here?
I couldn't get the day off work. I was going to try to study. Told me that I had court on the 29th.
You know, talk to the prosecutor, come back in. You have a seat right out in the hallway and they'll set you up. Good luck. Stevens Disposal, 260-647-612. Good morning, Mr. Osmond.
Good morning, Your Honor. Jeff Osmond on behalf of Stevens Disposal.
All right, so this could be a plea to overweight violation, agreed upon fines and costs of $400. And then you're going to also have the defective equipment will be dismissed, true?
Yes, sir.
You're authorized to enter that plea on behalf of the company?
Yes, Your Honor.
For the charge overweight, responsible or not responsible?
Responsible.
Plea is accepted. Fines cost $400, paid by March 12th. Defective equipment is dismissed. Have a good day, Mr. Osmond. Take care.
You too. You too.
Giles, Daniel Curtis Giles, 25T6460538. Do I have any of the victims here? I want to make sure that I don't have any of the victims here, and that includes Nicholas Cady. Is Nicholas Cady here? And if he is or isn't, is Benjamin Forrest here? Benjamin Forrest, Nicholas Cady. Mr. Gamber, good morning. Your appearance.
Good morning, Your Honor. Tim Gamber, on behalf of Mr. Giles, it's also President Flag, state your name, Gamber.
Daniel Giles.
Give me 1 second here. All right, so the defendant had previously pled disorderly conduct, to disorderly conduct,
One count, I think, but
and then the other two were dismissed. So I have the A file. The victims were notified. Again, are either one of those people on Zoom? Heather?
No, Judge.
Okay, so we'll go ahead and proceed. If you had a chance to review the report with your client, and are there any material additions, corrections, or deletions?
yes, Your Honor, we have a couple. We did have a chance to review it this morning. Under the current doctor's care, he is seeing Dr. Mackney, which is MAKHNI, and that's for his knee. Under the health section, it indicated good. He is still rehabbing a torn ACL. Shall I continue?
You don't need to talk about his medical.
I'm just talking about like accuracy, Judge.
Okay, good enough. Whatever you want. I mean,
I just like to make the record clear.
that's fine. I'll modify the report in that aspect.
The third thing, his employment status indicated that he hadn't worked since August 1st, and that should read October 1st, which is the date of the alleged incident. A fourth issue that we had, Judge, was that the probation department had recommended a site evaluation or basically, to be evaluated, and attend a mental health treatment as recommended by a approved agency. Your Honor, this is how we got here. He went into the hospital. He was anxious. He had some issues. He wanted to have his rest. Came out of a psych hookup a week later with a torn ACL. So that's how we got here. In my
Say that again.
he went to the hospital.
I know. And that's where he told him he had suicidal ideations, right?
Well,
And then he attacked the two.
that's the allegations that are meant,
Well, wait a
that's the
second.
allegations that are
Be
made.
careful with me because your client pled, you keep saying alleged. There's no alleged anymore. He pled no contest to disorderly conduct. I relied on the police report to establish a factual basis. It said he went over to Corwell. They were going to treat him. And he had suicidal ideations and started punching a couple of the attendants, the nurses, right?
That was the allegation.
Well, there's no allegation. Wait a minute, slow down. Stop saying allegation. This is a no contest plea.
That's accurately reflected on the.
Okay, so you allowed, you said you stipulate, when you do a no contest plea, you stipulated to the use by the court of the police report. And that's what the police report says. I mean, if he's, well, I'm just telling you, if you're going to continue to say allegations, maybe he shouldn't have pled to anything if he's denying any of this. I'm only pointing out why they recommended that.
Perhaps, I'll move along on that one.
Okay, go ahead.
And then just as far as the fines, Your Honor, it is clerk taking into consideration the fact that he has not worked and has not been able to since October 1st. And that's all the corrections or additions that we have on the pre-sentence investigation as well.
All right. Anything else?
Nothing at this time.
Sir, is there anything you'd like to say? I mean, your conduct was out of hand here. It was out of hand. And the prosecutor was very generous, and that's their business, and I'm not going to get involved in it, but you start assaulting people, and I realize, I'm just saying, I realized the plea was to disorderly conduct, but I relied on the police report, and all the police reports brought with is you punching these guys, and you telling them you had suicidal ideations. I'm going to go ahead and place you on probation for 12 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to undergo a psychological evaluation and treatment if recommended. You're not to have any contact with the victims, Nicholas Cady and or Benjamin Forrest. You're to pay fines in the amount of $200, costs in the amount of $150, $75 victims' rights fee, $50 justice assessment. So fines and costs are $475, screening fees $60 for $535, probation fees are $240 for $775. So again, no contact with the victims. Psychological evaluation and treatment if recommended. I want to order 5 days jail credit, 1 serve 4, and I'll let you serve those as follows. You're going to serve, and I realize you have this issue going on with your feet there with your ACL, 3 days court work program, 1 day community service, $105 in court work program fees. And I'll make sure that defendant not to be scheduled for court work program, not to be scheduled for court work program until at least August. And if you have a problem that prohibits you from still doing it in August, you bring your doctor's note and I'll revisit that. 1 day community service, I'll give you until May the 1st to complete that. That you can do that at any sedentary place. And the total here is $880. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. Any questions? Mr. Gamber, anything else?
Nothing, Your Honor.
So when can he pay these? Do you want me to set him up on a payment plan?
Yes, please. I mean, until he gets a job and is able to get some income, he's gonna need a payment plan if that's possible.
Yeah, I'll do $200 a month. And we'll start that beginning on July the 1st. How's that?
July 1?
July 1. And if he doesn't have the money to pay at any point, all he has to do is call the court. We'll go on Zoom. I'll give him an extension. You'll meet with probation here. Anything else?
I'll take this time, Your Honor.
Sure, anything else? Any questions? Best of luck to you. Luke Anthony Durant. Luke Anthony Durant, you will meet with probation, 262-647-447. Sir, you can come up right this way.
Right here.
Good morning, your name?
Morning. Who's right?
You're charged with disorderly places. Charging, they're saying you're the homeowner. The police have had 5 separate incidents that they were dispatched for: alleged kidnapping, hit and run, drug paraphernalia, MDOP, and overdose, along with numerous noise complaints. You have the right to a lawyer. If you want one, I'll be happy to provide you with one. Would you like a lawyer?
I would like a continuance because I had not had a chance to meet with my lawyer because he had a personal matter to attend to.
I don't have an appearance from anybody. Have you contacted a lawyer?
Yes.
Okay. I don't have a problem with that. I'll go ahead. I'll give you 2 weeks, okay?
Thank you, Your Honor.
And so we're going to adjourn this out to my next docket. You can go hire your lawyer and we'll see you back here. It should be the 26th, right, Heather?
That's correct, Judge.
We'll do 8:30 in the morning. So you and your lawyer can come in here then, okay?
Thank you, Your
All
Honor.
right. Any questions?
Understood.
Go right down the hall. They'll give you your notice. Thank you. Zachary Ryan Hines, 25G306-737 A and B.
Still act for the defendant. Good morning, Your Honor. Step forward.
Good morning.
I'm sorry I stepped out.
That's all right. I just need him to sign this advice of rights. Why don't you have him sign this first? Yes.
And Judge, can I just interrupt for a moment? We have
Sure.
Miss Medina and Mr. Cayley on for, just so we can address that Jose Rodriguez Medina before Mr. Cayley starts Judge Hessen's docket.
Yeah. Do you have the file, Roger?
The file should be in there with, I gave it to John.
Okay, good enough.
You want to sit down, Judge? Will.
Yeah, let me take that one real quick. He can take his time signing that and I'll move on this one.
Judge,
here.
I do have an update on that. As of the end of the day yesterday, we finally got a number from the defendant's stepfather.
Okay,
I do
let me
have an update.
call the case and then we'll put everything on record. People against
Okay.
Jose Gabriel Rodriguez Medina, 25F245-235. Mr. Cayley, your appearance?
Morning, Your Honor. Roger Kelly on behalf of People City of Flat Rock.
Good morning, Ms. Medina, your appearance?
Good morning, Your Honor. Crystal Marie Medina on behalf of Mr. Jose Rodriguez Medina.
So this is what I was told. This is a drunk driving, and there was something, it was from November 26 to 25. Apparently, he's in the custody of ICE. We had summoned, ICE had told us that they were going to have him on video, and I'm going to let you fill in, Heather, but this is my understanding. We got an interpreter here, right? She showed up. ICE never produced the client on video, so we rescheduled it today. She's written them a multitude of times. They have not responded, but now she's saying she got something yesterday. So far, did I say everything correctly, Heather?
Yes, Judge.
Okay, so go ahead and fill us in with the update if you would.
So I was given a phone number by the stepfather yesterday. He called. It was a direct number to the jail. I spoke with somebody at the jail yesterday. They provided me with an email address, which I emailed this morning. They told me to give it possibly 48 hours for a response, for me to get the information back on how to get him in front of a camera. So hopefully that will get us in the right direction to get him on camera now. I have a direct contact with somebody at the jail. So we should be able the next couple of weeks get him in front of the camera now.
So what do you want me to do? Just adjourn it without date, or do you want to schedule it on Mr. Cayley's next Flat Rock docket with me?
Well, our next Flat Rock docket, I'm hoping I did put in the email, as long as we can get it an interpreter. Our next Flat Rock docket is next Thursday. And I did state that in the email. If it's possible for us to get him on then, that would be great. If not, we would have to adjourn it to that March 3rd one.
All right, so that, Ms. Medina, I'm going to ask you to stay in touch with Heather, okay? And Mr. Cayley, you'll be here anyway if we can go next week. So I'll just say adjourn, date to be scheduled by clerk, but
Yeah.
you can, but go ahead.
Sorry, Your Honor, so yes, I would really hope, because my concern is, Ray, I'm trying to resolve the matter before there is any, more permanent maybe or potential movement with my client. And so I would try our best for the 19th if we could. What I would ask the court is, on that day, I believe I am in person in Howell. Would I be able to appear via Zoom, since my client's going to be on Zoom? And
That's fine. But you'll work out the time with Heather if they respond appropriately. I won't have a problem with that, okay?
Thank you, Judge. I appreciate you.
Ms. Medina, I will start CCing you on the emails.
Thanks a lot. I appreciate you, Heather.
Not a
Thanks, you
problem.
guys. All right, thank you. Hopefully we'll
Thank
see you
you.
next week on this. Thanks.
Hopefully,
All right.
thank you, Judge.
Thank you. Zachary Ryan Hines, 25G 306737A.
Judge, may I approach again? I have.
Yes, absolutely. All right. Okay, so your appearance, Mr. Zolnik?
We have Mr. Hines, state your name clearly, please.
Secretary, thanks.
All right. Good morning. So he's charged with operating while intoxicated. He's charged with refused PBT. As I understand it, prosecutor is going to dismiss the OWI. He's going to plead to operating while impaired. He's going to plead to refuse PBT, and he's going to join the sobriety court, right?
Is that right, Mr. Hines?
Yes, sir.
You sure you want to do that? You want to understand everything about it?
100%.
All right. Okay.
To help
Good.
Judge,
Good.
he indicated when we spoke about 3 seconds before I crashed my car 2 weeks ago, Mr. Hines told me that had he gotten the addressing of his sobriety issues in his first offense, he would never be here today. This is a critical moment because it's a life changer. He's a young man working for a governmental entity. He's going to lose his commercial driver's license for life. He'll never get it back. So he's going into family medical leave to get medical care for sobriety and then try to find a job when he becomes.
Okay.
So
Well,
it's a big step for him.
all right. So you understand everything.
Yes, sir.
If you plead guilty to operating while impaired, these are the possible penalties: up to 300 fines, 93 days jail, 360 hours community service, court costs, or all those. 4 points, license suspension or revocation in accordance with your record. And I will have to immobilize your vehicle here today. Do you understand that?
The car that you were operating at the time of the accident, the arrest, where's the car right now?
It's at my
All right, so there's no range with the court.
So I'll have to order a mobilization of that. Do you understand?
Yes.
If you join sobriety court, though, 45 days after sentencing, you're entitled to a restricted license that would enable you to drive to and, but, so these will kind of run concurrent. It's better for you with us immobilizing it now rather than at the sentencing. It's always my practice to do it at the plea, but I'm just telling you, I'll give you the minimum of 90 days. And by the time we get around to sentencing, you will be about 5-6 weeks in, and then you'll have 45 days till you're eligible for a restricted. You understand all that?
Can you explain your name?
Yeah.
I'm sorry.
It's all right. I have to order that you put a club on the steering wheel. A company's going to come out and they're going to put a club on your steering wheel. And I'm going to give you 7 days to complete that process. I will then sentence you because we're going to put you through a bond phase and you're going to be paying for a lot of things right now at your own expense, like testing, SoberLink device, anything that carries any kind of fee with it, we're going to pick up at the time of the sentence. So we'll pay for your SoberLink, we'll pay for your testing, so long as you test every time and you test negative every time. But it's really an arduous process. You're going to be going to testing 3 times a week. You're going to have to meet with me every other week, probation on the other weeks that you don't meet with me. You're going to be going to treatment. You're going to be going to AA. Lot involved. You're going to have to go to an ARM program. You're going to be living here in a lot of ways. Do you understand that?
Yes, sir. And I already went to the guidance center and I'm seeking treatment there.
All right. Let me take the plea first. I'm getting way ahead of myself. You did sign and read and understand the advice of rights, correct?
Yes, sir.
To the charge operating while visibly impaired, how do you plead?
13.
On November 23 at 25 at 12:44 in the morning, were you operating a motor vehicle in Gibraltar near Meadowlark in Gibraltar?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, sir. I was drinking beer and I had about 4 or 5 beers.
Okay. And why were you pulled over by the police? Do you know?
They told me I was smoking.
You think you were swerving?
I know I was smoking because the vehicle in front of me smoked.
All right. But do you think you were swerving? Let me put it this way, at least in part because of your alcohol consumption.
Yes, sir.
Did he take an intoxilizer or a blood?
That's a blood product.
And what were the results of that?
No, it wasn't a blood draw, it was intoxicating.
Yeah.
Would you remember the results? I get it in my file of briefcase.
I want to say 0.14.
That's right, 14.
All right. You stipulate that that was an accurate reading for purposes of the plea, Mr. Zolnick? And are you on probation or parole, sir?
Yes, sir.
We actually have a 0.150 and a 0.157. And you stipulate that was accurate? Sir, anybody force you to plead guilty?
No, sir.
All right. And to the charge of T refusal, you plead responsible or not responsible?
Responsible.
Okay, I'll accept the plea to operating while impaired. I'll accept the plea to PBT refusal. I'll dismiss the OWI, refer you for screening and assessment. You're going to follow all their bond conditions. We're going to give you a sentence date probably around the 3rd week of March, Heather. And so we'll put you through the bond phase. Hopefully you get through that with swimming colors and we can go ahead and accept you into the program.
Thank you, sir.
Your Honor, Mr. Hines asked the family, your mother and father, if there are any explanatory or cognitive issues that need to be addressed, they'll be here with them.
Okay.
That'll
Heather,
be
yeah,
March 18th, the judge at 8:30.
Very well.
at 8:30, March 18th at 8:30.
Thank you, Your Honor.
All right, sir, I wish you well. Go down the hall, get your notice, go meet with probation, make sure everything's in order, all right?
Okay.
Have a good day. Thanks, Mr. Susowitz. Brian Susowitz, 25F243700. Which one do you have, Mr. Westmoreland?
Ms. Wilson, you should walk in arraignment, but I was able to also retry it.
Okay, your name, sir?
Brian.
You're charged with a noise violation. You have the right to a lawyer. Do you want one?
Yes.
Where you been?
I've been in jail. I've been going through a lot of really stuff. I'm working.
How long you been in jail?
Like 92 days.
When?
I just got out.
You were supposed to be here back in May of 25. Why didn't you show up? You missed twice. How come?
I have no.
Didn't have a ride. If I hear that one more time, I didn't have a ride. You go out in the hallway, we'll set you up with a lawyer, okay?
All right.
Thank you. Do I have this lawyer's Blue Star equipment?
Yes, Your Honor.
I'm trying to find your file, so it's probably just overweight or something, right? Or
It is,
Do we-
Your Honor.
do we have Blue Star equipment up here somewhere, you guys?
Might be under this.
All right. People Against Blue Star Equipment LLC, 260-647-607. All right, your appearance.
Good morning, Your Honor. I'm George Howell, P 74468, appearing on behalf of Blue Star Equipment. I do have authority from my client to resolve this matter on their behalf. I've met with the city attorney, and we've agreed to stipulated fines and costs of $1,200.
All right, to that charge on behalf of the company of Overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted, $1,200 paid by March 12th, okay?
March 12th. Very good. Thank you very much.
Have a good day. Thanks.
Too. Thank you, Your Honor.
Yeah, this one has to be set up with a lawyer. And you said you have which one?
Ms. Wilson.
Tina Wilson. Tina Marie Wilson, 25G 82771A and B. You can have a seat there if you'd like, ma'am. Is that a cup of water or what is that?
Like this.
Well, I don't want you to vomit.
Me either.
Geez, oh Pete, relax. Take a deep breath and sit down.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Ms. Wilson.
Now I know why you think you might vomit. You haven't been here in 6 months. How come?
I'm very sick.
Okay, I'm sorry about that. Okay, so you pre-tried this, right?
That's correct, Your Honor.
Let me just figure out what we've got. We got an abandoned vehicle charge. What is this? It was property maintenance, abandoned vehicle on street. Okay. So she owes on that and she's going to plead to the civil infraction of loitering, right?
That's correct.
All right. So she's going to plead to loitering. They're going to dismiss the original charge on file A, and then she's going to plead. She's got the default judgment on the other case, right?
Correct, Judge.
Ma'am, you want to plead the loitering? Your lawyer did a good job for you. You want to plead the loitering? It's a civil infraction. You can't go to the charge of loitering, responsible or not responsible.
Responsible.
$150. Property maintenance charge is dismissed. So you owe $150 plus you owe the $213, I believe I saw, right?
I believe that was it, Judge. I'm looking real quick to double check it on that.
I thought I saw 213.
It is 213.
So you owe $363. Can you pay all this?
She's able to pay 100 today, and she would need a payment plan due to her health. She's unable to work, so she's.
Are you on disability?
No, she needs to be. Absolutely.
I signed up for it. It's in process.
Okay, all right. All right, so on the loitering charge, let's do the abandoned vehicle. Who's this with you?
Lady.
Her next door neighbor says, "Oh,
Well, that's nice. We all need good neighbors like that.
Yes.
All right. Is there a way you can come up with a little more, like $40 more on top of the 100? You pay one. He's shaking his head. Yes. Do you want to confirm that with him?
He wants my money for me.
You pay $140 today on the abandoned vehicle, and I'll waive the balance on that. Okay.
Thank you.
And you'll still owe $150, and I'm just going to give you on the civil infraction charge, I'll just give you until April 1st to pay that. Can you do that?
Sure.
They'll make it.
And if you can't pay by then, you call the court, we'll go on Zoom, I'll give you an extension. Just don't ignore me. I wish you well. You're fine. See, it wasn't so bad. You didn't throw up or anything. Good luck.
Thank you.
Good luck.
Have a nice morning.
Thanks, you too.
Couldn't move fast enough to get to the bathroom, so I brought it up.
All right, you're fine. Relax. All right, Joseph Zuko here. Which one does Mr. Hamid send me? What? Al Marisi? Do you guys have that? I'll call him next. I got it right here. I'll call you next. Zuko. 260-306-8198. Your name? All right, we're gonna adjourn this so you can clear your suspensions, right? I'll adjourn it to the 26th. Heather, what do you have? We'll just make it, what, 8:45?
Yes, we can do that, Judge.
We'll do it at 8:45 on February the 26th, okay? Go down the hall, get your notice, and you're all set. Thank you. Mozan Ami El Marisi, 26T 646-568. Good morning, Mr. Hamid. How are you? Your appearance?
Good morning, Your Honor. For the record, Mosabi Hamid, P34663, up here on behalf of Muslim Marasi. How are you, Your Honor?
Good. How about you? You're going to plead the impeding for him, and then they're going to dismiss the speeding, right?
That's correct, Your Honor. I'm authorized to handle this matter for him.
All right. To that charge of impeding, responsible or not responsible?
Responsible, Your Honor.
Okay, I'll accept the plea to impeding 170, and I'll give him till the 19th to pay, okay?
Thank you, Your Honor. Have a blessed holiday.
You too. Take care of yourself.
Thank you.
Thank you.
Thank you.
John, if you want to get that other case, Judge Hessen's Curtis, I'll just go ahead and I know.
I took it down already.
Okay, all right. Tashana Rochelle Curtis, 260 647 504 A and B. Your name, ma'am?
Sean Curtis.
All right, nice and loud. You're going to plead to no operator's license on person, right? They're going to dismiss the driving on a suspended, true? If you do that, the possible penalties are up to 100 fines, 90 days jail, costs, or all those. Do you understand that? And again, did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial or a hearing. Do you understand that? You have the right to a lawyer. Do you still wish to waive your right to a lawyer? Just keep your voice up for me, okay? To the charge, no valid operator's license on person. How do you plead?
Guilty.
Were you operating a motor vehicle January 18 of 26 in the city of Trenton, county of Wayne on Fortin or West at 1:16 in the morning? Did you have a valid license on your person? Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Please accept that the no ops, the suspends dismissed. I'm ready to sentence you. You ready? Anything you'd like to say? You got to stop doing it. And then you don't show up and you go out and got another one, apparently. 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days. You can go down the hall and pay that, okay? And you have that to pay, correct?
Yes.
All right. And by the way, did he address the defective equipment? Oh, and I'm also dismissing the defective equipment too. So you can go down the hall, pay your $295, and then go in front of Judge Hessen, okay? Good luck. All right, William Michael James. 23B726-981. Your name?
William Jacob.
All right, we're gonna call in Beth on this. You're charged with failure to submit to twice weekly chemical testing on January the 29th of 26. That is the charge. If you plead guilty, or if you are found guilty, this would be a first technical violation. You could get 5 days jail. Do you understand that? Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and she can appear from there if she wants, John. You'll be giving up all those rights, and there will be no hearing. Do you understand that?
Yes, sir.
All right. You have the right to a lawyer.
I got Crawford.
Oh, okay. All right. Yeah.
All right. Get Mr. Crawford in here.
Who's that?
Mr. Crawford.
Got my phone in there.
He's
Which Beth has this too, if you want to take care of it after.
okay. Why don't you have a seat?
But that's price.
Vince, would you please get Mr. Crawford in here for me?
Yes, sir.
Thank you. I'm gonna need some more of these. You maybe just kind of try to remember to. Well, probation violation sheet. These things, the arraignment hearing. So just. All right, you ready? People against William Michael James, 2-3B 726-981.
Good morning, Your Honor. My guilt Crawford, was an interference approach.
Sir, your name? Ms. Wild, your name?
Elizabeth Wise, patient.
All right, your client is charged with failure to submit the twice weekly chemical testing on January 29th. How is he going to proceed?
Your Honor, my client will be guilty.
If you plead guilty, again, this is your first technical violation. You could get 5 days jail. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and we're not going to have a hearing of any kind. Understand that?
Yes, sir.
To the charge that you failed to submit the twice weekly chemical testing on January the 29th, how do you plead?
Guilty.
Did you fail to submit the testing on that day? Did you fail to submit the testing on that day?
Yes.
Anybody force you to plead guilty? I'll accept the plea. What happened?
Your Honor, my client just blew it. He was missed the call, forgot the call, woke up early, gets up early, too long to work. I called him today, failed to call.
What day of the week was that?
What's a Thursday, and
Why'd you forget to call?
Well, he works 70+ hours a week. He was just getting off to work, gets up at 3:30. The place opens up at 4:30. It's on the stage. Just messed up just one time. He won't do it again.
You sure?
I'm positive. Tell when I look at and listen to him. A good judge of character.
Mr. James?
yeah, Mr. James is very compliant, Your Honor. I reviewed his file. I haven't been able to sit down with him yet since I took over supervision from Emily, but he's done with his work program, his community service, his sober link was spot on, VIP's done. He completed ARM. He indicated to me that he's completed with his outpatient. There wasn't a letter of verification of that in the file. I've already reached out to Anthony from Higuera to obtain that information. His money is paid. I do think this was a mistake on his part, a little lack of responsibility, but he is very compliant with his sobriety court term. And this should not affect his phase up at the end.
I'll accept the plea. I'm going to sentence you to pay costs of $75, and you have to serve 6 hours of community service by March the 15th, okay? 6 hours community service by March the 15th, and you're all set. Stay straight, stay narrow. Don't miss again, okay? All right, thank you.
Thank you, Judge.
You can do out the Summer Lori Greathouse.
I just have to grab her information.
Go ahead.
Upon violation, Judge.
Purdy. Mark Daniel Purdy. Who's your lawyer? Q6T 645-104. All right, your name?
Mark Purdy.
All right. You pled guilty under section 771.1 to the charge of firearm transportation, improper firearm transportation. I read your statement that you gave the probation. We've given you a copy of the pre-sentence report. Have you had a chance to review that report, and are there any material additions, corrections, or deletions?
I didn't review anything. I didn't receive it for the review.
Okay, we set that, she sent it to you on March the 5th or February the 5th.
February 5th? Was it an email or?
Yes, John, give him my copy of the report unless you have another copy. Here, you sit down there and you read this and we'll go from there, okay? And then once you're done, you tell my court officer and I'll recall him. Did you need something, Mr. Gamber?
Your Honor, I have an issue, and I'd like to try to address it off the record if we could.
What is the issue?
Can I come up?
Come on. Yeah.
This was. Originally said it, 771.
They didn't write that, nobody had that on, no.
Yeah, I know, and I just talked to the prosecutor and he basically advised it was mischecked. I thought that we had little something to be accountable.
Well, then get them in here, get the file. Talk to me about it.
You know, I just want to make sure, Judge, whatever, however, look, I feel like, you know, that
It wasn't on the sheet.
no, I know. And I just feel like,
Get the prosecutor. Who was, is that a Trenton case?
Yes.
Yeah, get the prosecutor.
we have it on the record.
Well, we can do chambers. I'm fine with going in chambers, the three of us.
Okay,
Okay?
thank you, sir.
Sure. Okay, are you ready on that?
Yeah.
I'm gonna need the file too, John. Heather, I'm gonna need that file back on that,
What's the name?
I have it.
okay.
Should I keep it or give it back?
You can give it to my court officer, Mark Daniel Purdy, 26T645-104. Your name?
Mark.
All right, so you pled to illegal transportation of a firearm. I read this. I think it was an honest mistake. You had a CPL, but it expired how much? Well, before we go on, I need to tell you, you have the right to a lawyer.
Yeah.
Even though you waived it before, you still have the right to one, and if you want one, I'll give you one. Do you want a lawyer? Did you review this pre-sentence report?
Yeah.
Is everything in the report accurate?
Yes.
Okay, so there's nothing in here that you need to tell me different, right?
Nope.
Okay. What would you like to tell me?
About,
How long did the CPL expire before you?
I had redid the course and I have the certificate. I just hadn't took it to the sheriff's, the sheriff's office, do the background check and all that stuff again. I just didn't do it and then it lapsed. So it's only good for maybe, I don't know, 2 years or whatever it is. I just forgot to take it down there, but I usually don't carry my guns on me anyways, even when I had.
I know, you were taking it over to your brothers.
Yes,
Is that all true, what you wrote in the statement?
yes.
You were taking them there because you were going to be out of town for a couple of weeks?
I was leaving out of town, yes.
And your
Yeah.
kids, you had kids at home?
Yeah, I have a safe that I use at his house. He has a big safe, gun safe. That's where my guns go if I'm out of town or
All right.
work or anything.
Anything else you want to say?
No,
Is there any reason why you need to undergo a psychiatric evaluation?
no,
Have you ever undergone that before?
no.
6 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. I am taking this under section 771.1, so if you're compliant, I'll dismiss. You're to attend a handgun safety prevention program. You're going to serve 2 days of community service. Your community service in this case has to be done no later than April the 1st. I'm going to give you a review hearing date. You have to attend a handgun safety program and do the community service of 16 hours by April 1st. Fines are 100, costs 100, 75 victims' rights, $50 justice assessment, 60 screening fee. Your total there amounts to $385, and you have probation fees of $120 for $505. You stay out of trouble, you pay your fines, do your community service, attend that program. I'll give you a review hearing date. Be glad to dismiss the case. I think it was an honest mistake here. I'll give you a review hearing date in 6 months. You are eligible for early discharge after half the time. So if you do everything, you can get a hold of the prosecutor and you can say, hey, do you mind moving to dismiss this after 3 months? Okay, that's their bailiwick. I mean, you're entitled to early discharge, but when it's under a statute, they're very, very, very likely to sign off on it. So Heather, why don't you give me a date in late July or whatever, very early August?
We can do August 6th.
August 6th at 8:30. Sir, and can you pay all this today or do you need time?
What was everything in
505.
505? Yeah, I can pay it.
Okay, you pay that now, you'll meet with probation and you're all set. First, go down and get your notice and make your payment. Best of luck. Thank you.
Does this go with this?
Yes. let me do your bond violation and then we'll get prosecutor in here. Summer Lori Greathouse, 25F 245-336.
Judge,
Your name?
Elizabeth Laws, probation, Your Honor.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor. I just passed up to you because there are numerous violations, numerous positive blows on sober link. So I just, that way you have that in writing.
This is the one with the fourth offense.
That is correct, Your Honor.
And are you adopting this? You've got a document that says, and I can read them real quick. She was positive for alcohol in the sober link on February 8 at 7:27 p.m. She was positive and with these numbers corresponding on this document. February 9th at 11 a.m., 11:17, 11:34, 11:53 a.m., 3:26, 3:44, 7:22, 7:40, 7:57, 11:22, 11:39 p.m. Also on February 10 at 11:27 and 11:44 a.m. Also on February 10 at 3:27, 3:44, 4:02, 4:19, 4:37, 7:29, and 11:18 p.m. And then again on February 11 at 11:25, 11:43, 12:02, 7:11, and 11 p.m. She failed the blow, right?
That is correct, Your Honor.
This is the document you prepared?
That is correct.
Sign it, will you, for me, please? I'm gonna find that there's been a violation of defendant's, defendant has violated bond conditions. I want you to go into Mr. Longton's office. I want you to tell him I'd like him and his client to appear here if he's available this ASAP this morning.
Yes, Your Honor, in person?
In person. I'm issuing a bench warrant, revoking the release, forfeiting her bond, and issuing a bench warrant pending a hearing. The bench warrant will be in the amount of 10,000, 10%. Boy, this is not good. Thank you.
Thank you.
So call him and see when he can come in.
I will, yeah.
Get the prosecutor, if you would, counsel. I'm going to take this one. Susowitz, Brian Susowitz.
Yeah.
This is 25F243700. Does he really want to do this under is this under 771?
I don't believe so.
He just put it under that.
If he did, that's fine with me.
I mean, the guy just was in jail for 93 days. I mean, it's a noise violation. I mean, if you think you want, I would just give him fines and costs. He's got a heck of a record. If he was going to go to become a priest or something, I would, you know what I mean?
Yes.
He just wrote it in this line that he usually checks a box for statute. He didn't do that. Noise violation.
That's what he proposed to me, that he had to plead guilty as charged. And
recommend fines and costs.
Recommend fines and costs.
I'm fine with that.
Sure.
But we're not going to fool around with 771, right?
No, I wasn't even aware of that.
Okay, good enough. So do you understand? State your name. Do you understand what your lawyer just said? So first of all, I guess I gotta have him, he's gonna stay in mute, wait formal reading for arraignment purposes.
He will, Your Honor.
And then he's going to plead guilty to a noise violation with the prosecutor recommending fines and costs only, right?
Yes.
Is that what you want to do?
Yes.
That is punishable by up to 500 fines, 90 days jail, costs or all those. Do you understand that?
Sure.
And did you sign, read, and understand the advice of rights? You plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge of noise violation, how do you plead?
Yes.
Were you at Walnut Creek Drive, 28227 Walnut Creek Drive, Flat Rock, April 4, 25 at 3:54 in the morning?
Yes.
Were you yelling? Were you yelling racial slurs?
I might have, I was John.
Why would you be yelling racial slurs? I'm sorry?
I'm not sure.
I hate that. I always think when somebody, is making slurs about anybody, they must be emperor of the planet or something. You know what I mean? Like, who are they? I hate that.
unfortunately, alcohol can fuel a lot.
Yeah, I know,
Discussed that.
but we don't usually say things unless we feel like them, whether we're drunk or not. That's my issue with it. All right, I'll accept the plea. I'll go along with this fines and costs, but you're gonna pay some fines and costs. Anything?
Yes, Your Honor, the gig is working, but he does have some obligation, Your Honor. He has a family that he supports and some other bills as well. So this is not a violent offense, fortunately.
I know.
So I'm asking for a minimal amount of fine.
I just don't like these. I just don't understand it. Anything you want to say?
I was in a bad state of mind. Wasn't living how I was supposed to live. There's not an excuse. I understand that.
Your record is horrible.
I know I'm trying to turn it around. I got a daughter now. I got 2 months away.
I just don't, there's no place for racism in our society. Don't people think it's cute? I find it disgusting. 200 fines, 225 costs, 75 victims' rights, $50 justice assessment, 550 or 90 days. I'll let you pay this at the rate of 50 per week. And you can start to pay this beginning on February the 27th. If you need more time, you come talk to me. Don't be doing that. Good luck. Thank you.
Judge, he does need to go over to Judge Hesson's now. He has a
Need
case
to go
over
to
there.
Judge
too.
Hesson's too. Come on back here.
All right, take care. Go to that cell first. Yeah.
The court will consent to hear the matter. Court does call the cases of the people versus Jesse Ivy.
You had indicated that you were going to retain counsel. It's my understanding you have not done that. Is that correct?
Correct.
All right. Do you not have the funds to hire an attorney?
I chose not to, yes. My son is going to grad school and he would have to pay the attorney and then I would have to pay him back, which until I get out of here, I don't know if I will still have a job and can afford to pay him back. So I'd rather do this on my own and he can have his money for grad school.
All right. So do you want me to appoint you counsel then?
I put in a few messages about that, but if that's going to take another week or so, I'd rather just kind of discuss what's going on. And
Well, I can't really discuss what's going on until we sort out this counsel issue, because you have a right to counsel, and if you don't want to proceed with counsel, then you have to make a waiver of counsel,
Right.
and that has to be done knowingly, intelligently, and voluntarily.
yes,
And at this point in time, so you need to make that. You really need to make that decision first before we go any further.
and well, I'd like to waive because I just like to try to get on with my life and figure out everything. Please.
All right, Mr. Logs is going to hand you a form. It is a waiver of counsel form that you need to review and.
Thank you.
After you're finished reading,
Here we go.
sign where it's marked.
Thank you.
David, what's that number? Thank you. All right, Ms. Bauer, is that your signature?
Yes, sir.
Did you read this document?
Yes, Your Honor.
Can you believe you understand what it says?
I do.
And you understand that that by signing this and waiving your right to counsel, you'll be representing yourself. You understand that?
I do.
You're giving up a very valuable right.
I understand that.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No, they have
Are
not.
you under the influence today of any drugs or alcohol?
No, I am not.
All right, the court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I will accept that. Now, as for the allegations of the violation of your probation, do you want to have a hearing or do you admit to the violation?
I don't want to go any further than today, so I would like to admit with explanation.
Okay. What is your explanation?
Well, first of all, this has just been a long process and I have wanted help the whole time. My son is very aware that he knows when I'm drinking and when I'm not. He knows I've been doing everything that I've wanted to do to get better, and I have done everything. I quit a job that was my dream job to try to make things work and get out of a worse atmosphere. I was driving here for probation meetings for 5 hours away at 2 a.m. to get here on time and on my only days off and going back to work, and I quit that job. I have since gotten 2 other jobs that were $70,000 a year. The first one I lost because after 30 days, they did a background check and found out about all this. I quickly got another one and was on the way there from going to probation to fill out all my paperwork. So I have no idea if I have that job or not. I also got on Medicaid in 4 days. I moved back here for this as well, and to take care of my father because I was in Florida with my own radio show. I came back here and I was working and got another charge in Indiana. And the very first call I made was to Officer Torg. I have kept in constant communication of our entire relationship. There are thousands, probably, I'm exaggerating, but probably 100 at least emails proving of my contact, which I know he's extremely busy. I'm not his only priority, but I never get return answers. And I have tried everything I've done. I got unmedicated 4 days so I could pay for the $10,000 IOP that I had to take care of, which I got on immediately. And I graduated from the day before I was arrested this time. And early, I didn't ask to get out early. I didn't even know when it was going to end. So I was going in the mornings, doing that, and then going straight to work and working till midnight. And I have not had a decent night's sleep the entire time due to SoberLink because I have to set an alarm to wake up. And sometimes it doesn't even wake me up. My health has been an issue. Everyone, I think, knows that. And I have gotten, since I was on Medicaid, I've gotten in primary care. I got back on my mental health meds. I was starting this day after I got arrested. I was to have my first individual therapy session to continue with the IOP, which they told me I was ready to go, which I said, and I even stayed an extra week. He said, you can go this week or next week. And I said, I enjoy it. I'm not trying to get out of anything. I wanted help because I knew mental health is a big part of my issue of drinking. And since I've been here, I went 7 days without my blood pressure medicine and 7 days without my Prozac, which I had gotten on and was doing well on both. My blood pressure was 170 over 114. And they never even took it again. And when I didn't show up I blew positive on the SoberLink. 15 minutes later on the retest, I did not. I had been vomiting for 2 days because I was ill, which I communicated. I got summoned on a Sunday night to come in here for the third time. I live an hour away. Other times I showed up and I was negative. And this time was on bed rest. I have 2 doctor's notes. I have a note. It was a level 3 snow emergency from an hour away. And I contacted and I came several times every day. And no one would answer. So I contacted the attorney and he said, you should have this, no problem. I think you're completely creating this in your head. Why in the world would you think they're going to arrest you? And I said, because they have in the past. So I came and I got arrested and I don't know if I have a job anymore and my medicine's all screwed up now. And I'm not drinking. I'm not doing anything wrong. I feel like I've had to jump through 500 hoops and I'm doing it because I spent a lot of time researching the place to go so I would get mental health, not just substance abuse.
And I found a really good place, and the counselor was great. And I just want to get on with my life and contribute to society like I have been. I've never been on assistance in my life, and I've had to go on SNAP. I just want my life back. Today, my rent is not just due, it's of course past due. It's the day where they're going to break my lease if I don't pay it or have my son pay it. And then I'm going to have to sell my car because unless I still have my job, and then I can pay my son back in time. But if not, I'm not going to be able to. He doesn't have the money to do that either. So I'm going to sell my car, and I don't know what I'll do after that. But I know that I don't belong in here right now. And I know that I'm not the only one. And I know I don't make the rules. And I know I don't run Officer Torque's schedule. And he's been very good to me, but I can never get in contact with him. And I've talked to his boss. I've talked to his partner, Officer Evans. They all return calls. And that's the only issue. And I just want to, if I have to, I was told if there was any more issues with the sober link, I'd go on the ankle bracelet. I don't care. I'm not drinking. It doesn't matter. I wasn't wanting to wear it because it worked, but I'll just have to get long pants. I just want my life back, and I don't want to hurt my son anymore.
So you're just crazy in a retard kind of way then, huh?
My bunkmate had a seizure this morning. I had to roll her over on her side, and I don't even know if she's okay. It's people are snorting coffee in the bathroom. I mean, it's just a lot. I just really want to get back to my life and do good things and not be in trouble anymore. My individual therapy is going to be the most important part because I've had a lot of trauma and I've never really dealt with it. I've just worked too hard and ignored it and drank and shoved my feelings down. And I'm just now opening up and dealing with all that, and I got my meds back, and I was doing great. I just please want another chance to get my life back, please, before it's too late, and then I don't have anything left.
Ms. Bauer, thank you for all of that. Obviously, I have people that come before me every day that have excuses and want to offer reasons for their behavior. A lot of what you said to me is just that, excuses. You've had an alcohol problem for more than 25 years. This case did not deal with alcohol, but it dealt with methamphetamine. Now you're claiming you have mental health issues, which is odd since I just reviewed your pre-sentence investigation, and other than having ADHD, you did not report any mental health issues at the time. To see people when they do the pre-sentence investigation or an ILC assessment, they often try to minimize to the assessor what their issues are. But for over 25 years, you've been struggling with alcohol. You've been through treatment a number of times, and yet you continue to come in here and offer to me excuses. A lot of times when defense attorneys get their clients deals, and you got a great deal here because you went from a felony to a misdemeanor. Your attorney did you, and it could be it's a disservice at this time because the consequences are significantly less for a misdemeanor than they are for a felony. So once again, here we are, and you have been unable to comply with the terms and conditions of your probation on a misdemeanor. So you avoid the felony charge, but you really have not gotten the help that you need, and maybe it's going to take rock bottom. But Officer Torque has been here for a number of years. He is an excellent supervising officer. I have every faith and all confidence in him. And for you to sit there and to badmouth him and to say that this is somehow his fault that you find yourself in the Warren County Jail it's to me ridiculous. So I'm not going to listen to any more. Based on Officer Torque's recommendation, this is not working. You're not supervisable because you're not going to follow the rules. So I'm going to order you to serve 90 days in the Warren County Jail. You'll get credit for the 20 days that you have already served, and then you will be terminated from supervision. Just keep in mind that if you do not follow the rules at the county jail, if you misbehave and have received an infraction there, that additional days could be added to your sentence. Ms. Tranter, is there anything else?
No, sir, thank you.
All right, that's all.
Thank you. I'd just like to say that I did not badmouth him. I pointed out facts that he never returns my messages. Thank you for everything.
Yeah.
You said 23, did.
All 6 cases. Where's my
It's
sheet?
Mr. Gaddy. It's Mr. Gaddy.
Sorry. For Mike.
I haven't seen
Hang on. No. Mr. Gaddy.
That's a great question, Judge.
Okay.
Oh,
You were the one responsible to get everybody. No, you failed. Go ahead, Mr. Feaster.
thank you, Judge. The Feaster, first assistant public defender on behalf of Mr. Ivy, standing next to
Mr.
Gaddy.
Mr. Ivy, can you state your name, please, sir?
Jesse Ivy.
All right.
Thank you, Judge. And speaking to APA Chabalowski, sorry, I believe we're waiving this matter up to circuit court for further resolution.
So he's doing a waiver on all of this.
That's my understanding, Judge.
Is that your understanding, Mr. Ivy?
Yes.
I didn't hear you, sir.
Yes.
Yes?
Yes.
Okay. Sir, you're waiving your right to a preliminary examination in all of these matters. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all, I believe, 6 counts.
Thank you, Judge. Well, we will waive reading and ask the court to stand mute, Your Honor.
Defendant having waived formal reading, standing mute as to all counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
March 11th at 1:30 with Judge Conlon.
March 11, 2026, 1:30 before Judge Conlon.
Thank you, Judge.
Thank you. Bond in these matters will continue. Thank you. You'll take them.
Yeah.
Court does call the case of the people versus Derek Jones.
Morning, Your Honor. Joy Fanstein, Assistant Public Defender representing Mr. Jones. Your Honor, I was just approved yesterday to be able to schedule a visit to meet with Mr. Jones. I'm asking for an adjournment and I'm filling out the green sheet right now.
Mr. Jones, can you state your name?
Derek Jones.
All right. And you were unable to schedule a visit, is that what you're telling me?
Yes, Your Honor.
Well, probable cause conference in this matter will be adjourned to March 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you, sir.
I do have a question for you, Honor.
Court does call the case of the people versus Demarion White.
Andrew Childers here on behalf of the people.
Killable distracted me, Your Honor. So, good morning, Your Honor. May it please the solemn court, David Burgess on behalf of Damari and White, is appearing via Zoom from the juvenile center, Your Honor.
Mr. White, can you state your name, please?
Good morning, White.
Thank you. What are we doing?
Your Honor, Mr. Childers and I are speaking regarding an ultimate resolution in this case, but we're asking for a little more time. So an adjournment of the PCC is requested.
5th or the 12th, what's better for you?
Either is fine.
5th is fine, Your Honor.
Probable cause conference will be adjourned March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Judge, Your Honor, can we just approach on a collateral matter? I apologize. It'll be quick.
Your Honor, Senior Assistant Public Defender, representing Ms. Petoskey. Ms. Petoskey, would you please state your name for the record?
Margaret Petoskey.
Your Honor, I did submit yesterday, late a plea form for
Yes, it was late,
yes, I'm acknowledging.
but I don't.
A plea form for, no contest plea for Ms. Petoskey. And Ms. Petoskey, we went over your rights to a trial and,
I don't have the plea form, so I have the police report, but I don't,
It was not signed.
that's why. With permission or otherwise, it was not signed. So it wasn't.
So I would like to apologize. Many of these procedures were not procedures a year and a half ago when I was last here. And so I am catching up on the procedures. So I
understand that, Ms. Gaines.
And I will.
I blame that on everybody else that's around you that should have explained it to you.
So if we could pass for a short moment, I know this is very important to Ms. Petoskey. Her outdate has passed.
Okay.
Thank you, and I will get that stuff.
Joanne Crawford. Pardon?
Good morning, Judge. My name is Alan Cooper for Joanne Crawford.
Your Honor, good morning. For the record, Mark Burke, P 54935 with the Attorney General's Office appearing for the people.
Name, sir.
Joanne Crawford.
Your Honor, it is our ultimate intent to try to waive this exam, although I haven't actually had an opportunity to speak with my client about it. I was wondering if perhaps we could maybe address the issue of bond so I could have a better chance to meet with him and then have a better conversation with the prosecutor.
Well, that may not, I mean, you can argue it, but I think his bond is set pursuant to statute in this case at 25% of what he owes. So
yeah, I understand that, Judge. I think that sometimes that it's overlooked that the statute does require a good cause exception. I understand that it provides for.
Oh, no, it's not overlooked. I look at that every time.
And the issue
So
is,
if you want to make your argument, go ahead and make your argument, counsel.
Okay, great. Well, the thing is, my client does have a job that's waiting for him for February 17th. So obviously, the whole point of this case, with the child support case, is to try to get money and get payments to try to get his arrears paid down. So that's a real truck in Ann Arbor. I actually do have a copy of the letter showing his job offer. So he's supposed to start there on February 17th. So our hope is to get at least some kind of bond so that way he can start working. So that way, obviously, at some point, we're going to negotiate this case and it's going to involve payment of some money. So he can't do that if he's not working. So I don't want him to miss this opportunity for employment when it's right there waiting for him. So he does have the family in the community. His mother's supposed to be there at court. I just got off the phone with her. She's at the courthouse. He's got substantial family in the area. So I would ask for a personal bond. He takes care of his father, who's an amputee.
I'm sure, counsel, that he was working at some point before his child support got to over $25,000, right?
He was unemployed for a substantial period of time, and he tried to file some motions to modify his child support over the last year or two, but he tried to do it improper. So of course, he didn't get a proper hearing date. So our intent is to backdate that, and we're going to go through the civil court as well. It's not going to completely reduce all the arrears, but it's going to have some reduction if we can go retroactive back to the date when he first filed those, because he was unemployed for a significant period of time. But the problem that I have is that he's got this job waiting for him. I don't want to miss this. I don't want him to miss this opportunity, especially when he's going to have to end up paying something towards some arrears.
Any response from the people?
Your Honor, thank you. The only thing I would indicate is the court is certainly well aware of the statute. It's 750.165. It does require 25% cash bond in the amount of the arrearage. Judge, the arrearage currently, as of 2 days ago, is north of $32,000. The bond that I see that I believe is that's ordered is $63.95. I mean, quite frankly, it's probably low compared based on what the arrearage is today. But the other thing also is I appreciate counsel's argument that he wants to work and he wants to start paying. But the reality, Judge, is the defendant has an ongoing obligation of $555 a month right now. He's paid a total of $1,500 in the last year. That's it. So, I mean, and I don't think he's been in custody that long. So, in any event, I mean, I'll leave it to the court's discretion, but a PR bond is definitely not within the statute. So, let's keep the position.
I think the statute specifically does provide for a good cause exception. I think the fact that this case is a nonviolent offense, it's financially.
I don't find good cause, counsel. He's now, the bond actually is low of the 25% because we set it based upon 25% of what's in the complaint. From the time of the complaint till now, he obviously hasn't paid because that amount has grown by almost $7,000. And so there hasn't been anything paid. I in this and don't find, based upon the argument, a good cause exception to the 25%. I won't raise it based upon the number given by the state today, but I'm going to leave it where it is, which means it's going to be lower than the 25%, but something's got to be paid on this. So motion for bond reduction is denied.
All right.
As to this case, what do you want me to do with it?
Well, personally, I'd like to waive the exam. So we're fine waiving the exam.
Well, does your client want to waive, or does he understand what that is?
I haven't had a chance to speak to him yet about that, Your Honor.
Probable cause conference will be adjourned 1 week out. February 19th, 2026, 9 a.m.
Thank you.
Sir, he'll talk to you and then we can figure out where we're going. Understood, sir?
Yes, sir.
Thank you.
Your Honor, thank you.
Bond continued. Thank you.
Mr. Cooper, thank you. If you want to talk, give me a call anytime, okay?
Court calls the case People versus Tyler Oliveira.
To the people. Assistant Public Defender Ben Dunworth on behalf of Mr. Oliveira, who should be appearing on Zoom from MDOC.
Yes. But we got to get him unmuted. Oh, he is. Mr. Oliveira, can you state your name, please?
Tyler Oliveira, can you hear me?
Yes, sir, we can. Thank you.
Okay.
What are we doing?
Your Honor, this is Mr. Oliveira's first court appearance. I have not yet been approved by MDOC to meet with him, but I did request so on Monday. Defense would have to ask for 2 weeks to meet with our client.
Probable cause conference is the 26th going to be enough for that to happen? Or am I going to get here and adjourn again?
They don't turn the form in?
Pardon?
Do not turn the form?
No, is that going to be enough time, the 22 weeks? Is that going to be enough time for you to get approved, meet with your client and do something productive? Or do you need an additional week?
We'll take 3. Thank you, Your Honor.
Probable cause conference, March 5th, 2026, 9 a.m.
Thank you.
Round continued. Yeah.
Thank you, Your Honor.
So what is that? Is this what's going to do?
No.
Court does call the case, People versus Brian Laster. He's not going to reign it.
Correct.
Which one?
The last.
Attorney Feaster, Assistant Public Defender on behalf of Brian Laster. Mr. Laster, how are you?
I'm fine. How are you?
Good. Please state your name for the record.
Brian Ian Laster.
Thank you, Judge. I did reach out to the prosecutor on this case. We are working on trying to get a resolution to this file. To date, we have not yet resolved it. Hopefully, we can come back in the near future and get this matter resolved. Be asking for a brief adjournment, Your Honor.
That's fine. Do you realize he has another case?
I did not, Your Honor.
Been rather sort of a cluster getting it here because we're not sure what happened, but we have a duplicate.
Oh.
It's a charge of larceny in a building, the 4-year felony.
Okay.
I'll give you the case number. It's 26F5 5030.
Okay. Thank you so much, Judge. I will include that in my I will include that in my discussions with the prosecutor.
I was told I was less than $200 in the charge I'm here for now. I'm not aware of what the charge is here for today.
Okay.
I was adjourned. I was free.
Okay.
And the $200 from a
Let's not
mill.
talk about
Well,
the case.
hold on, Mr. Laster.
And this stipulation charges are
Mr. Laster, I'm going to ask you to be quiet. I don't want you to say anything about the case at this point. And certainly counsel doesn't know about that. I'm just why don't we just go through the arraignment on this? Mr. Laster, the complaint alleges that on or about November 8th, 2025, location of 210 South First Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of larceny in a building. Specifically, it indicates that you did commit the crime of larceny in a bar or public house by stealing from the cash register drawer and stealing from the cash register drawer cash, and then 3 bottles of High Noon seltzer, contrary to Michigan statute. I'm not asking whether or not you did it or not, but do you understand what you were charged with?
Understand?
Excuse me. Yes, I understand.
All right.
And
that's a felony punishment by.
Was afforded to.
Pardon?
The guy across the street.
Let's not talk details of the case today, because Anthony said he's finished.
All right.
So you understand what you're charged with?
Yes,
sir?
I do.
You understand that that's a felony punishable by up to 4 years incarceration?
Yes, I
and
do.
a $5,000 fine plus court costs.
Yes, I do.
Do you wish to be represented by an attorney?
Yes.
Mr. Feaster, take over, please.
Thank you, Judge. Torrio Feaster, Assistant Public Defender on behalf of Mr. Laster on the new file. Laster on the new file. Your Honor, we would waive any form of additional reading and we would stand mute, Your Honor.
Defendant, every way from a reading standing mute, court will enter not guilty plea. I will set probable cause in this case. How much time did you need on the other matters?
Just a couple of weeks, Judge. We had a fairly decent offer.
Right.
Maybe we can incorporate that.
That's fine. I'll set a probable cause conference for February 26, 2026, 9 a.m. As to his bond in this case.
Your Honor, I believe he's had the bond in his other cases.
Pardon?
I believe he had the bond in his cases he's in for right now. I'd ask for a low bond on this one as well. Give him credit on everything.
Well, what's he in on? I have 1,000 cash or surety on one of them, and one of them also he has a personal recognizance bond.
Yes, that sounds right, Your Honor.
Pardon?
That sounds accurate.
What I'll do in this case, I'll set his bond. He's got other cases, so I can't do. I'll set it at 5,000, 10% at this point. other standard conditions, including no assaultive behavior or possession of any weapons. You're not to possess any alcohol, recreational marijuana, or any illegal drug. I will also indicate that he is not to enter 210 South First Street in the city of Ann Arbor.
Thank you very much, Judge.
Thank you.
Thank you, Judge.
You're welcome. Court does call the case of the people versus Margaret Petoskey. Well, where's Miss Gaines? If I,
Oh, my God.
Ms. Gaines?
pardon? Well, yes, because she's the one. Pass it briefly. Court does call the case of the people versus Jayla Allen. Jayla Allen.
Good morning, I'm Charlotte Stefan on behalf of Ms. Allen.
Good morning. Your name?
Jayla Allen.
Jayla.
It's okay.
All right.
Your Honor, I was just appointed last night to this, so I'm requesting an adjournment. Would 4 weeks be okay with the court?
Probably not, but you need 4 weeks.
Yes, Your Honor.
Hearing no objection, probable cause conference will be adjourned to March 12th, 2026, 9 a.m.
Thank you
Found
very
that
much,
this
Your
matter
Honor.
will continue. Thank you. Court calls the case people versus Kadena Self.
On behalf of people, Your Honor.
James back.
Good morning. Good morning, Your Honor. Christina Saxon from the Self. Please state your name for the court. Kadena Self.
Thank you. What are we doing?
Your Honor, would like to make a bond argument and set this for preliminary exam.
Discovery is complete.
To my knowledge.
What date are we on? People have their witnesses available the 24th. Preliminary examination in person will be set February 24th, 2026, 9 a.m. before Judge Barr. As to bond.
For myself to be released on tether. Since the last time we were here, I've learned, excuse me, that the alleged victim in this case has been arrested and charged. When we were here last time, her arm was in a cast, and that was from a domestic violence event with him. They do not reside together, so I'm asking for a release with a tether. And in addition, just to show
Do you
that
think something has changed since the last time I denied bond?
I have more information about that, the fact that you only heard that there was a stabbing. From the looks of this, it actually warrants me having it looked at to make sure that he had not done that based on the angle of the marks. So, yeah, that has changed. It's a presumption that warrants more consideration. And on a side note, she wanted me to let you know she completed her GED for language arts yesterday. So she has used her time in here so far wisely.
Response.
Your Honor, I would object again at this time that previous case that was mentioned by Ms. Saxon was dismissed, I believe, 2 weeks ago. The facts that I brought with the court before I also she was out with intoxication as well. So at this point, I object.
Motion for bond reduction is denied. Bond will continue. Take a look at it again. Thank you. The court does call the case. People versus Kobe Fletcher.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Fletcher. Mr. Fletcher, could you please state your name for the court when you get up here?
Kobe Fletcher.
Judge, hoping for an adjournment to review discovery.
That objection, probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Bye. Let's call the case, People versus Edna Grima. Grima.
Good morning, Honor. Charlotte Stefan on behalf of Ms. Gurma. Your Honor, unfortunately, there's been a breakdown in the attorney-client relationship, and I have to ask to withdraw from representation.
Your name?
Edna Gurma.
What?
May I be allowed to speak, Your Honor?
Go ahead.
Okay, Your Honor. I couldn't have. Wait. Okay. Excuse me.
Bless you.
Thank you. I couldn't have a regular, attorney from public defender because it was conflict of interest or whatever. So
Right.
I have from the county, right? Okay. Your Honor, my question is, if I request, if I ask the no probable cause to be handled right here, right?
If you ask for what?
If I ask her,
Okay.
okay, let's just put it like this. She and I were talking and I was stopping her to ask her questions,
Okay.
make sure I'm following her.
Okay.
And she didn't like that.
She didn't like what? Did you ask a question?
Yes, sir. She said, if you stop me one more time while I'm talking, then I'm going to get up and leave. Your Honor, I'm 61 years old, okay? I have to ask the question.
So you're going to tell me that Ms. Stefan stopped you without cause to stop you,
What?
was trying to, as she's trying to explain things to you, and that somehow or another that did what to you?
No, what I'm saying is that she was explaining her thoughts on, she was telling me what she was going to do, right? As far as the case. And I was stopping her to make sure I understood what she said is what I was doing. She didn't appreciate me stopping her.
Or what she was telling you is, let me get through what I'm going to tell you, and that then I can answer your question.
But I have a hard, I'm trying to follow her as she go along, sir. That's all.
That's what?
I was just trying to follow her. I'm trying to follow her as she goes along, because by the time she gets to the end of what she's saying, I may not remember my question. So if you say, after probable cause, if I ask after probable cause, then what's the next thing? See, first of all, I just want to say, I beg, I pray to God in Jesus' name, and I'm praying right now.
Man, what do you want me to do?
I'm asking you to please forgive me, find grace and forgiveness for me breaking my bond thing, as well as I have a nonprofit youth organization. My nephew was killed in 2021.
Ma'am, right now,
yes,
your attorney has said there's been a breakdown in the attorney-client relationship.
I don't understand.
You don't understand that? So you don't, well, you got up there trying to be critical.
I kind of do.
You kind of do what?
Understand it, because she and
Do
I.
you want Ms. Stefan to represent you or not?
Do I want her to represent me? She don't want to.
I don't think Ms. Seven has ever turned anybody away. You need to listen to her, though.
What did she say?
So you, what did she say? To me?
Yeah.
She just said there's been a breakdown in the relationship, but I'm trying to understand that.
So now what? I'm just confused. I don't understand.
Maybe that's why when your attorney comes to talk to you and she stops you, she's trying to make sure to explain everything to you.
Okay.
Which means you have to listen.
Okay.
So what do you want me to do?
Forgive me for breaking my, do I want her to be my attorney? Is what you,
Well, that's where we need to start.
okay. Do you want to be my attorney? Do you think we can work it out?
Your Honor, with all due respect to the court and Ms. Girma, I do feel bad about this, but I don't think that it's at this point fair to Ms. Girma to have me continue to represent her because it got, in my opinion, it got to such a point that I'm here now asking to withdraw. And Your Honor, I probably have, it's very rare if ever. So Ms. Girma deserves an attorney that she can effectively communicate with. I'm certainly willing to try, but I just don't think that's in her best interest at this time, Your Honor.
Yes.
So would you please forgive me for breaking the bond thing and please?
Ma'am, I'm not even dealing with the bond. I'm trying to make sure you have an attorney that you're going to listen to and can communicate with. But if Ms. Steffen is coming before this court, I don't think she's ever withdrawn a case before me and asking or believing that she cannot properly represent you. I'm going to take her at her word.
Okay.
So what I'm going to do is we'll need to have I won't require a written motion, which I normally do to withdraw. I'll take the oral motion to withdraw as granted. Ma'am, what I'm gonna do is, since I doubt the MAC office knew about it, I'm gonna adjourn it out 1 week so that they can have time to appoint counsel to present you. So the probable cause conference will be adjourned to February 19th, 2026, 9 a.m. At this point, your bond was revoked. Your bond will continue as revoked until we can get through everything. So our bond will continue revoked. Thank you.
Thank you, Your Honor.
You get to. Yeah. Court does call the case, People versus Edward Bryan.
All right, good morning again. For the record, Mark Burke, P 54935 with the Attorney General's Office, appearing for the people.
Oh boy, here we go.
Good morning.
You good today?
I am good.
Okay, go ahead.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Stephanie Cannon.
All right. Permission to practice is granted.
Thank you, Your Honor. We would like to adjourn this matter.
Is she here?
Oh, sorry.
No, I didn't hear noise in the room, so I figured Cannon wasn't here. But
Just walked out.
I'm talking about the defendant. Vern, can you state your name? I don't.
He's on Zoom, Your
Okay.
Honor. Looks like he's muted.
Mr. Okay, there he is. All right. All right. You're
Oh,
asking
yeah,
for
sorry.
what?
Good morning, Your Honor. I was muted. Sorry. Good morning. Sorry.
All right, we got you.
Okay.
So you're asking for an adjournment?
Yes. Until after around like March 19th, if possible.
To March 19th?
Yes.
What's
I have
going to
a
happen
friend of the
then?
court hearing on past payments for arrears on March 6th, sir. It was
Well, thanks
scheduled
for
for,
interjecting. Okay, what?
I had a meeting canceled due to the weather up there on past payments on my arrears. It's rescheduled for March 6th at 10 a.m. through friend of the court.
So counsel, the reason that you're asking
The
is
reason that,
because there is a hearing
yes,
and you're waiting for time for the results of that hearing to happen, and you think that will happen by March 19th.
absolutely,
That's what you would have told me had you not been rudely interrupted.
exactly.
Okay.
Yes.
Oh, sorry. Shoot.
Do the people have any objection to an adjournment to that date?
Your Honor, the defendant posted bond. People have no objection to that. That's fine. As long as the defendant waits the 21 days, which I assume he already
Yes,
has.
I think they already have on the form they have. All right. Probable cause conference will be adjourned March 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Your Honor, thank you very much. Have a great day.
All right, you do the same, sir.
Thank you.
Court calls the case, People versus Tanvir Ahmed.
People. From Public Defender Jay Bellinger on behalf of Mr. Ahmed, who approaches, Your Honor. Good morning.
Good morning.
Can you please state your name for the record? Tanvir Ahmed. And Your Honor, we are just asking for a 2-week adjournment as we are in the heavy throes of negotiations.
Could I make a finding on this already?
Your Honor, I didn't see one in my files. So I did submit one because I saw that the last report came in on 2-3 and I just wanted to.
On what?
On 2-3, that's when it was uploaded to my file for him. I just didn't see one in our file that had been given to the court. So I do apologize if there's been a second one received.
Well, no, I don't think there's been a finding on competency at this point.
I think that we need to do that first and then.
Yeah, well,
Apologies.
That's what I'm saying.
Okay, I apologize.
So have you reviewed?
We have. We have. We
Any
stipulate to the
additional
findings.
evidence?
No additional evidence.
Any additional evidence of the people?
No.
The court would find that the defendant is competent to stand trial.
Thank you.
The court specifically would indicate that the defendant can understand the nature and optics of the proceedings against him and can rationally assist in his defense. So I'll need an order on competency.
I did submit one to the court, Your Honor.
You did?
I did.
And now what did you want to do?
I'm just asking for a 2-week adjournment.
That probable cause conference in this case then will be set for February 26th, 2026, 9 a.m. as your bond, or as your invite indicates bond.
Thank you very much. We will be in touch with you.
Court calls case, People versus Samira San Paulo.
And is it on behalf of the people?
Roberto, on behalf of Ms. Dampolo, Samira, please unmute yourself, state your name for the record.
Samira Dampolo.
Thank you, Your Honor. At this time,
Thank you.
Thank you, Judge. At this time, discovery is complete. We are asking that the matter be set for preliminary exam.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Preliminary examination will be set.
Excuse me, I have a
February.
question. I am in one court important for me, but I don't know. So, I don't.
Excuse me? Oh, that was not her. Okay. In the Dantoyo matter, the matter will be set for preliminary examination February 24th, 2026, 9 a.m. before me. Bond will continue. Thank you.
All right. You can log off, Samira. You're all set. Thank you, Judge.
Thank you.
Court does call the case, People versus Ronald Fleming.
No, it's not me. No, soon.
Assistant Public Defender, I'll stand in today for Mr. Johnson. If Mr. Fleming allows, Your Honor. My understanding is Mr. Johnson's unavailable. My understanding is that he has communicated with the people. I'm sorry, Stephen for record, sir.
Ronald Fleming.
My understanding is that he's communicated with the people and with the court that he's requesting an adjournment on the file.
Who's requesting an adjournment?
Attorney Johnson, Kareem Johnson.
Oh, you're standing in. Do you have any objection to him standing in, sir? Pardon?
No, sir.
All right.
I can't hear anything.
Did he indicate how much of an adjournment or how long?
He said that he would communicate with the prosecutor and the court directly about a next date. I'm assuming he did not do that since you're looking at me.
I have not heard.
So I would ask for 3 weeks, I guess.
I have no objection to 3 weeks. I don't have an exact date, and we called me with it.
March 5th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. I'll need a green sheet submitted on his behalf, Mr. President. Court does call the cases of the people versus Joseph Hodson. All 4 cases.
Hey, Judge Cabral, on behalf of Mr. Hodson in the matter ending in 5232.
Assistant Public Defender Ben Dunaway for Mr. Hodson. We have co-counsel Kyle Breedell.
I'm on Zoom, Mr. Denowith.
Okay, so where's your client?
Your Honor, this is the date and time set for a competent review hearing. Unfortunately, I've placed several phone calls to the number we have for Mr. Hodson, as well as emailed him without success. Mr. Brito, have you been able to contact our client?
I haven't either. I don't believe I have a good phone number for him.
So, Your Honor, given that the Forensic Center found him incompetent but restorable, we'd ask for an adjournment for 2 weeks so that we could attempt to contact him.
And I would join in that motion on my case as well.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. Those warrants will issue immediately on all these cases. Thank you.
Thank you, Judge.
Court calls the case People versus Kurt Rushland.
Morning, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Bushline, who approaches. Your Honor.
Your name, sir?
Kurt James Bushline. Your Honor, I believe we have a resolution in this case, but it's contingent on Mr. Bushline taking a plea up in Ithaca County. I believe that's set for March 16th.
Yeah, I go.
The sentencing date on the case in Gratiot County is March 16th.
And I misspoke, Gratiot County, Your Honor.
Which is it. So we're asking to adjourn until after the sentencing date so that we can then.
So it isn't a plea, it's a sentencing date.
He entered a plea up there, Your Honor. He'll be sentenced on the 16th. The offer from the people was, the plea was after.
Probable cause will be adjourned March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Calls case People versus Jaleesa Robinson.
Morning, Your Honor. J. Grant Miller, P58658 on behalf of Ms. Robinson, who should be on Zoom.
Ma'am, state your name.
Jaleesa Robinson.
Thank you.
Your Honor, we're discussing the negotiations. I believe there is a discussion of an amount of restitution. We're asking for an adjournment after March the 1st to see if my client can come up with those funds.
Files conference March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Matthew Kennedy.
Morning, Your Honor.
And Assistant Public Defender, Shenanigans, Your Honor, on behalf of Mr. Kennedy. Is it? I have.
One?
Yes.
Okay. And good morning. Go ahead.
PD's on a 22 matter.
Good morning, Your Honor. Please, the Honorable Court, David Burgess on behalf of Mr. Kennedy as it relates to the 26 matter.
Okay, what are we doing? You're asking for an adjournment.
We both are, Your Honor, so.
Probable cause conference, March 5th. Is he held on anything else other than these?
I don't, do you have another hold?
Just these 2 cases, right?
I think it's just
Just these 2 cases, Your Honor.
Probable cause conference, February 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
And just for the court's information, I did see some out of county traffic holes.
Oh. Yeah.
Thank you.
I'll see you for next.
All right. Court calls the case, People versus Gary Coward.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Gary Coward. Your Honor, discovery is complete in this matter. We're requesting exam. Oh, thank you.
People have their witnesses available the 24th. Preliminary examination in person, February 24th, 2026, 9 a.m. Bond before Judge Barr. Bond will continue.
Thank you, Your Honor. All right.
Court does call the case, People versus William Matthews. Then let me try to get Ms. Potowski.
William, state your name. William Herman Matthews, Jr.
He's waving.
Judge, yes, but before he waives, Your Honor, while this court has jurisdiction, I'm asking if his phone privileges can be restored. I'm not quite sure why it was nothing nefarious on his behalf, but we're asking that the court restores phone privileges. And then we're going to waive up the circuit court.
I didn't know.
Pardon?
Everything's turned off. I can't go to store. I can't do anything. Nobody know why.
What are you saying this court revoked it?
It wasn't the court. It was somebody in the jail, I guess. I don't know. I've been trying to find out for 2 weeks, and they just keep saying it won't accept my.
Does the people's file reflect that I revoked it?
I don't think this is the first time it's even been in this book.
That's right. That's what I have. So I don't know where.
Something wrong with the jail, I guess. I don't know.
Can you be of any assistance?
I could, but I won't because it's not my order.
All right, I'll discuss it with the
Is
jail.
he gonna waive?
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
You will also waive the right.
That's right.
Preliminary examination having been waived, defendant bound over to circuit court on the single count. Mr.
Judge, we acknowledge receive the information, waive its reading. My client would stand mute.
Defendant ever waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
February 26th at 1:30 with Judge Slay.
February 26, 2026, 1:30 before Judge Slay.
Thank you, Ron.
Thank you. Bound will continue.
Thanks, Judge.
Thank you. Court does call the case People versus Abdul Latif.
Right, Judge.
Good morning, Your Honor.
Still speaks to Assistant Public Defender on behalf of Mr. Abdul Latif, who appears to be on Zoom. Please take your.
Sir, I'll need a camera and to state your name, please.
Good morning, Your Honor. This is Abdul Latif.
Thank you, Judge. We are requesting a brief adjournment to determine whether or not a motion can be
And
filed.
you'll explain to your client next time he's in court, so you shouldn't have his
Should I?
everything on.
Yes, Judge.
All right. I'll adjourn this matter. Probable cause will be adjourned to March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Court calls the case People versus Theodore Enke, maybe.
Good morning, Your Honor. David Kennedy on behalf of the people. To carry out.
No, take your time. We're good.
That was moving fast.
Your Honor, on behalf of Mr.
Your name, sir?
Anthony. Judge, we need to, I put in a request for investigation, so we need to explore that a little further. That's why we're asking for an adjournment.
Is this the only thing holding him or?
It is.
It is. Is 2 weeks going to be enough, given what you want to do, or you need 3?
Let's do 2 weeks for
2
starters,
weeks.
yes.
Probable cause conference, February 26, 2026, 9 a.m. Bound continue. Thank you.
Thank you.
Court recalls the case of People versus Margaret Pataski.
Joy Gaines, Assistant Public Defender representing Ms. Petoskey. Thank you, Your Honor, for the moments to get everything in order.
Your name, ma'am? I need her unmuted. Ma'am, can you state your name?
Margaret Petoskey.
Thank you.
Mhm.
I have a plea form before me that indicates that the defendant is going to be pleading no contest to the charge of use of methamphetamine, the 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Margaret Petoskey.
Okay, you can put your hand down. Ma'am, it is this court's understanding you're going to plead no contest to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
2 things about a no contest plea. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability.
Ma'am, to the charge of use of methamphetamine, how do you plead?
Guilty.
Really?
No contest. No contest. I mean,
Thank you.
I've been trying to get this over with since December 12th. I'm sorry. I'm having a little anxiety right now.
Okay. All right. You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You had signed or caused to be signed an advice of rights on your behalf?
Yes, I hope so.
Well, did you give your attorney permission to sign the advice of rights?
Yeah.
Okay, after going through that with her?
Yes.
All right. Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all those rights, including your trial rights, which are contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? No.
I was supposed to be released from MDOC on December 2nd, and this is holding me up. So I will be on parole once I get out.
All right, but you are not currently on parole.
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Michigan State Police report. I think was the name. Really? I don't need all this stuff. Michigan Department of State Police report for their case number 720724. Any objection to the court having reviewed that report?
Okay. No, Your Honor.
Since I'm gonna just get rid of this, it's my case anyway. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt to this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, thank you, Your Honor.
The court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Ma'am, anything you or your counsel want to say before I impose sentence?
Your Honor, Ms. Petoskey does have 62 days of credit as of today, and she has no objection to immediate sentencing and is asking for a sentence to 62 days of credit for time served.
Ma'am, anything you want to say?
Just that you would take that into consideration, please. I have completed everything I needed to do here. I completed my building trades for Volk Village. While I was waiting to be sentenced with you, I've completed ServSafe. I just really want to go home.
Understood. The sentence of the court, $125 state minimums, 62 days in jail, credit 62 served. You're all set. Good luck to you, ma'am, when you get out.
Thank you.
Thank you.
Thank you, Your Honor. Good luck, Ms. Petoskey.
Court calls the case, People versus Andrea Acre. I'm not doing that again.
Public Defender, Chinaza Carriac, Ruli, Your Honor, on behalf of Miss Andrea Acre.
And now, okay. Acre,
Yes,
state your name, please.
Andrea Acre.
And I submitted a green sheet. We're going to be asking for an adjournment to explore potential conflict that we identified. The people have extended an offer, but I need to confirm if it's a conflict in my offer.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Oh, yeah, that's
You say,
fine.
ma'am?
No, I was gonna say something. I was thinking I had an appointment then, but a doctor's appointment, but I don't. I'm good. Yep, that's perfect.
All right. Thank you.
Yep.
Court calls the case, People versus Kristen Anthony.
On behalf of Ms. Anthony, can you please state your name for the record, please?
Kristen Nicole Anthony.
Thank you.
Your Honor, in this case, we would like to, our client would like to waive her right to a preliminary exam.
She wants to waive up.
Yes.
Is that correct, ma'am?
Yes, Your Honor.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you will not have that hearing
Yes,
and
Your
that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived. Defendant is bound over to circuit court on all 4 counts.
Thank you, Your Honor. We also would like to request that our client can be released to inpatient treatment.
Oh,
sorry. Your Honor, we will waive formal reading of the information and we ask that you set this for pretrial.
Defendant having waived formal reading, your client is standing mute. Is that correct?
Yes.
Defendant standing mute, court will enter a not guilty plea as to all 4 counts. Pretrial will be set for
February 23rd at 1:30 for Judge Smoot.
February 23rd, 2026, 1:30 before Judge Hamud. Bond will continue. I will sign an order. You get it into me today for jurisdiction is absolutely lost for a release to inpatient. Otherwise, you'll have to take that to Ms. Hamud, Judge Hamud. You have it here. Any objection from the people?
Yeah, we do object to the police treatment. As I recall, this defendant in a prior release to treatment or trying to get into treatment, I think while on bond, if I remember correctly, again, used the victim's insurance information to try to get into treatment. So I don't know that
Did she do that or are you just suspecting she did?
my case notes are saying that we got information as on December 1st, the defendant had used the victim's insurance to try to get admitted to a treatment facility. Before she was arraigned in this case.
Before what?
Before she was arraigned in this case. I apologize.
So she tried to do that on another case? Is that what you're telling me?
On another date, yes, in December.
I think people can raise that before Judge Hamud as to how that's going to occur. I'm going to sign the order. I'll release you to treatment. And then Judge Hamud can deal with it. Thank you. Court does call the case People versus Nico Caillou.
Christina Sachs on behalf of Nico Siu. I'm standing in on behalf of Edward Drucas, CO's permission. Is that correct, Mr. Siu?
We're trying to get him unmuted. Sir, state your name.
Caillou, but good morning, Your Honor.
Good morning, sir. All right, you have, your attorney is Mr. Drucas. You don't have any problem with counsel stepping in at this point, do you?
No, I do not.
Okay.
Your
You're
Honor,
requesting an adjournment?
Yes, for Nito discovery.
Is this the only thing holding him? Do we know?
I do not know yet.
Man, you got any other cases holding you right now?
Your Honor, he does. He does have a few other matters. One he's recently arraigned on, and he has bonds on all of those.
Probable cause conference. I'll adjourn this to March 5th, 2026, 9 a.m. Bond continue.
I'm sorry, you said March 5th.
Thank you.
Thank
you, sir.
Thank you, sir. Have a good day.
You too. Court calls the case People versus Kyle Burmeister.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burmeister, who approaches, Your Honor. This is for you to complete.
I have before me a plea that indicates that the defendant would be pleading to 3 counts. The stated count 3, well, of malicious destruction of property, 200, less than 293-day offense. Also to added counts 4 and 5 of attempted resisting and obstructing a police officer, 1-year offenses. Upon his successful plea to those three counts, counts 1 and 2 would be dismissed. That's the court's full understanding.
That is our understanding as well, Your Honor.
Is that the understanding of the people?
Yes, Your Honor.
All right, let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Kyle Burmeister.
Sir, it is this court's understanding that you're going to be pleading guilty to three charges. Is that correct?
Yes.
First is the charge of malicious destruction of property less than $200. That's a misdemeanor punishable by up to 93 days in jail. $500 fine plus court cost. The fine could be increased if 3 times the value of the property injured or otherwise destroyed. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. And also that you'll be pleading guilty to the charge of attempted resisting or obstructing a police officer. That is actually 2 counts of that. Those are misdemeanors punishable by up to 1 year incarceration or $1,000 fine plus court cost. You understand that?
Yes.
All right. You understand, sir, also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
To the charge of malicious destruction of property, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer as contained in count 4, how do you plead?
Guilty.
To that same charge as contained in count 5, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of record.
Yes.
Are you on probation or parole?
Yes.
You are? Were you on it, probation or parole at the time of this offense?
Yeah.
Yes, which one?
Is that the 15th? Yeah. 15th District Court, Your Honor.
You were on probation?
Yes.
All right. You understand that your entry of a plea in this case could be a violation of that probation?
Yes.
You understand that as such, and if it is considered that court could sentence you to the maximum allowable under that other charge?
Yes.
And still, that means you still, or just understanding that, do you still wish to plead guilty to these 3 charges?
Yes.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
December 16, 2025, at the location of 3550 Plymouth Road, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do on that date involving a 2020 Ford F-150?
The door was damaged in the truck.
Pardon?
The door was damaged in the vehicle.
Did you kick or, may I, Your Honor?
Please.
Did you kick or strike the truck? Okay. And that was a 2020 Ford F-150 pickup truck?
Yes.
And the result to that truck was damage under, and you would agree that the amount was under less than $200?
Yes.
And that vehicle does not belong to you?
Yes.
And you had no property interest in that vehicle?
No.
Correct?
Correct.
You then came into contact with police officers in the Ann Arbor Police Department?
Yes.
What happened?
Pulling and having a hard time.
Pardon?
They were having a hard time.
They were having a hard time?
We were. I was.
Your Honor, may I?
Yeah, please.
Thank you.
Because I don't think they had a hard time, but go ahead.
Thank you, Your Honor. You were being transported at that time. You were arrested by the police and you were being transported by ambulance personnel. Is that correct?
Yes.
And one of those ambulance personnel's name was Libby Kelly.
Yes.
And you understand at the time she was a paramedic performing her duties.
Yes.
And while you were restrained on the gurney during transport, you physically grabbed or attempted to grab her arm.
Yes.
And you agreed that your actions physically interfered with her ability to do her job safely.
Yes.
And you also agreed that the conduct was voluntary, even though you were intoxicated at the time.
Yes.
Your Honor, if I may, just for the other one.
Yeah, go
And after arriving at the hospital, you had contact with Ann Arbor police officers, including Officer Judge McNally, correct?
Yes.
And you understand that Officer McHenry was police officer performing his official duties.
Yes.
And while officers were attempting to restrain or control you at the hospital, you physically resisted them or attempted to.
Yes.
And you did that by swinging your arms or kicking.
Yes.
And in doing so, you made physical contact with Officer McHenry, correct?
That's right.
And you agree that your actions physically interfered with his ability to perform his duties?
Yes.
Satisfied, Your Honor?
So I do have to advise you that if I accept your pleas, between the time of my acceptance of your pleas and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, nor would the court be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court ruling would be proper to accept this defendant's pleas?
Yes, Your Honor. Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
March 3rd at 9 a.m.
March 3rd, 2026, 9 a.m. That is before Judge Garwood. Bond will continue. Thank you.
We'll get you sentenced.
That's very.
Court does call the case People versus Amanda Barrett Chitane.
Michael Gaddy, Assistant Public Defender for Ms. Barrett Chitane, who's making her way to the podium here.
Your name?
Amanda Barrett Chitane.
What are we doing?
Your Honor, we'd ask the court to set an exam in this matter.
Discovery is complete.
Yes, Judge.
Question mark.
Oh, I said yes, Judge. Sorry.
People have their witnesses available the 24th. Preliminary examination in person will be set February 24th, 2026,
Thank you,
9
Your Honor.
a.m. before Judge, before me.
Thank you. Have a blessed day.
You do the same. Bond continue. Court calls case of the People versus Marquita Clements.
Brother Judge. Courtroom Feaster, Assistant Public Defender on behalf of Ms. Clements. When you arrive at the podium, look for the record.
Marquetta Clements.
Marquetta, apologies. Thank you, Judge. Our office has spoken to our client and to the prosecutor on this file. We're going to be requesting a adjournment on this file to try to find a resolution, Your Honor. We can have a couple of weeks, please.
Probable cause conference, February 26, 2026.
Thank you, Judge. I know
9 a.m.
I know my client also wanted to apologize, Your Honor. I believe last time she was here, there was an outburst with the court, and I know she wanted to take some time and tell Your Honor she was apologetic for how that played out, Your Honor.
I do sincerely apologize. It was out of impulse.
Out of impulse, you need to learn to control that.
Yes, I'm not on my medication right now. I just turned in my Stonecrest papers to the person.
Our fellow. Yes, I believe she had previously requested a bond modification to go into treatment. And I believe she has a job, and I know she would like the court to reconsider her bond request, but she understands in light of how she acted at the last court date, the court may not be inclined to do so today.
I am not inclined to do that.
Thank you, Judge.
So our bond will continue as revoked at this point. Thank you. Court does call the case of the People versus Brandon Boggs.
Yeah, I can move it on behalf of Mr. Boggs. Boggs, statement for the record, please.
Brandon Boggs. Thank you.
Your Honor, we are asking for an adjournment for investigative matter. I think that 3 weeks will be fine. I have been
Public
assigned.
cause conference, March 5th, 2026, 9 a.m. bond. Thank you.
Thanks, Greg.
Court calls the case of the People versus Joseph.
Your Honor, Raymond Cook for the People.
Griffin. They already stated theirs. Go ahead.
Assistant Public Defender Ben Dunaway on behalf of Mr. Griffin, and I'm just gonna get this.
Your name, sir?
Joseph Bertram Griffin, Your Honor.
Thank you.
Yes, sir.
What are we doing?
Your Honor, Mr. Griffin is going to waive his exam today.
On both cases?
Sir. Sorry up there. And that is in exchange for people agreeing one appeal at circuit court if you would choose to take advantage of that.
And that is the agreement as long as you pay for restitution from dismissed cases.
Thanks.
Sir, you're waiving your right to a preliminary examination in both of these matters?
Yes, Your Honor.
And you understand that that's a proceeding where people would have to show by probable cause that the offenses alleged were committed and you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having standing mute, waiving formal reading of the complaint. Court will enter a not guilty plea. Pretrial will be set for
February 23rd at 1:30 with Judge Simpson.
February 23rd, 2026, 1:30, Judge Hamoud.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue. Court calls the case of the people versus Amaya Campbell.
Assistant Public Defender, Chinaki Kariaki, on behalf of Ms. Maya Campbell, who should be on.
Campbell, state your name.
Amaya Campbell.
All right, what are we doing?
We're asking to set this matter for preliminary examination, Your Honor,
Discovery is complete.
to our knowledge.
Five, the witnesses available the 24th.
If it's possible, the only reason I'm asking is there's a co-defendant, but it's not. Consent this meeting for the third, just so there's a little bit more.
Got it. Any objection?
I didn't hear what he said. He just said there's a co-defendant. You want to see her in the afternoon?
No, I was looking just to go 1 week further tomorrow.
The co-defendant's case is set, so he wants to go out a week, so there's some flexibility.
I don't see a problem with that.
No problem. Preliminary examination in person, March 3rd, 2026, 9 a.m. Bond continued, or before Judge Fresh Hour.
Thank
Bond
you.
continued.
Thank you.
Thank you. Court calls case people versus Richard Hall.
And then on behalf of the people.
Your Honor, Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Hall. Would you please state your name, sir?
Richard Hall.
Your Honor, new approach.
You in?
Okay.
What are we doing on this case?
Your Honor, we're asking for a preliminary exam.
So your discovery is complete.
That is my understanding. We do have the police report and I do believe there was media in this, and we have that as well.
All right. People have their witnesses available the 24th.
We'll do our best, Your Honor.
preliminary examination in person, February 24th, 2026 at 9 a.m. before Judge Barr. And as to bond in this case, my understanding, go ahead, Miss.
Your Honor, it came to my attention that the defendant has made 12 calls to the listed number for the victim from other pins. We confirm that this is her number as I also stumbled upon a text to the victim as well. So this time I'm going to be asking for a phone this and text questions to be revoked.
All right. Any response?
No, can I say something? I haven't made no text. She had texted me from the number and I ended up blocking. Yeah, I didn't never text her.
He's saying it is not text.
Pardon?
I haven't texted her. But it was a text that she had sent and I ended up blocking it. I never said nothing to her.
Well, here's what I'm gonna do. Do not test here. There will be an issue, I don't think. But what I'm gonna do is I'll continue as bond. But at this point, I'm going to revoke his phone and texting privileges. All right, we'll take a closer look at it. All right, thank you. Court does call the case People versus Marcus Jones.
Ready again, Judge. Floor shall cease to Assistant Public Defender on behalf of Mr. Jones. Mr. Jones, please state your name for the record. He's muted, Judge. If you can wave to the jail behind you and ask them to unmute you and then state your name. There you go. State your name, please, sir.
Marcus Jones.
Thank you.
You're requesting an adjournment.
Yes, Judge. We're still negotiating this matter, trying to see if there's going to be an offer made.
26th or the 5th.
26 is fine, Judge, please.
Probable cause conference, February 26, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Calls case People versus Todd Johnson.
Michael Gaddy, Assistant Public Defender with Mr. Johnson. Your Honor, he's approaching. What date is I need? Your Honor, we're here for you know why we're here. Your Honor, I've gone over his right to a preliminary examination with Mr. Johnson, and he wishes to waive that examination. The people have agreed that upon a waiver of the exam, they will not add any habituals.
Is that correct, Mr. Johnson?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, I do. I understand.
All right. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Gaddy.
Yes, Your Honor. In terms of the information, we'd waive reading and stand mute.
Defendant having
Acknowledge
waived reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for.
At 1:30 with Judge Slay.
Your Honor, if I could, I believe that Judge Ahmoud was his judge last time. I don't know if since Judge Slay was covering two dockets, if once Judge Ahmoud became, she's now his judge for life.
I don't know. I have Judge. Who do we have as this case?
They have Slay on the docket here, Judge.
Who do you have?
I know Judge
Is the
Ahmoud.
well, in JIS, is our up Judge Slade? Because that's what I'm going to set it before. I'm not going to deal with this. What?
Yes, it says Judge.
What's her mood date? February 23rd, 2026, 1:30, Judge Hamoud.
Thank you, Your Honor. If I could be heard on a bond condition.
Go ahead.
It's a condition. Oh, I'm sorry. Your Honor, this is a unique situation. Mr. Johnson has a PR in this matter. being held on a MDOC hold. He would like to request that he be released to treatment if we can clear that with his parole agent.
I don't have a problem. I'll sign the order if it comes to me today.
Thank you, Your Honor.
Releasing him. No, I'm not gonna have an issue with that.
Thank you, Judge.
At this point, bond will continue. Thank you. Court does call the case People versus Enrique Davis.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Davis.
Your name? Eric Davis. Eric. That's not Enrique. Got it. All right. It's okay. I'll call him whatever.
Your Honor, we have reached out to the prosecutor for negotiations. Negotiations are ongoing. We're asking for an adjournment, and I do have the green sheet.
Probable cause conference, all adjournments matter, March 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Yes.
What?
You got that.
I do. I don't know what that's about. Court calls the case, People versus Carl Murray.
Andrew Childers, appearing on behalf of the people.
Assistant Public Defender, up here on behalf of Mr. Carl Murray. Your Honor.
Your name, sir?
Carl Murray.
Thank you.
Judge, it's going to be a waiver.
Waiver. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Correct, yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count. Yes.
We acknowledge receipt of the information, standing mute, asking the court to enter a non-guilty plea and waive formal reading.
Defendant have waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
February 25th at 1:30 with Judge Conlon.
February 25th, 2026, 1:30 before Judge Conlon.
Very briefly on bond, Judge.
Yes.
Your Honor, Mr. Murray already has matters in front of Judge Conlon. On those matters, he has been given the opportunity to be released to treatment. We wanted to ask if this matter could be.
I'd release him. I just need an order today, though.
Okay. I'll say.
Bond continued. Court calls the case People versus Jesse De La Garza.
And then on behalf of the people.
Morning, Your Honor. Jesse De La Garza.
Assistant Public Defender Ben Dunaway for the defense.
Briefly. Yes.
Or it can get this contact order. So we'd like to set this for exam and we would like to address bond.
All your discovery is complete.
Yes.
People have their witnesses available the 24th. Preliminary examination in this matter will be set February 24th, 2026, 9 a.m. before me. As to bond?
As to bond, Your Honor, the complaining witness has called the public defender office multiple times, including talking to myself. She's indicated she does not want a no contact order, so the defense would ask for consensual contact.
Response from the people.
There's another DD case open in 14B final settlement on 227, so I believe there's a no contact order in that case as well. I also have concerns that now we're here on another case that is a felony domestic violence case, so I have significant safety concerns and would be objecting all this time.
The complaining witness is in court, Your Honor, so.
There's another domestic violence out of 14B in which there is a no contact provision.
That's all.
And right, I think we can get that changed at the next date. And if it's the final settlement conference, you know, they can either settle it or it can get dismissed. I think what's in front of the court today is the complaining witness who's present.
Well, I understand what you think is in front of this court, Mr. Denoway. What's in front of this court is making sure that everybody is safe. I have a case where there is a no contact, which is a domestic violence against this individual. You're asking, whoever's asking it to be lifted, the court's going to make the determination based upon what's there. So the way I look at it, if there's one matter that's pending, that's a DV, he's now here on a felony DV for that person. I normally would hear from the victim as to their wishes, but the court is inclined not to change it and will not change it. Motion for bond modification is denied. Bond will continue. Thank you. Good. Court calls case Bill versus Brandon Myers.
Okay, well, for the people.
Glenn, on behalf of Mr. Myers, can you please state your name for the record, please?
Brandon Myers.
Good morning, Ms. Myers. All right, what are we doing?
Your Honor, we would like to adjourn this case to see if any new charges are authorized, and we also would like to submit an order for him to be released to inpatient treatment.
So there are other charges?
It's already been authorized, Judge. It's in the pipeline. I don't know where or what status it is. It does, I can't find it or couldn't find it. Public website, but it's somewhere out of our office, obviously.
Probable cause conference and matters, bless you, will be adjourned to March 5th, 2026, 9 a.m. I will sign the order releasing the treatment. Very familiar with Mr. Myers and probably could use it, right? So I'll sign that order and hopefully we'll have everything together once on the 5th. Okay?
Yes.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Tegan Donald.
Assistant Public Defender on behalf of Ms. Tegan Donnell, and I do have a plea form and advice rights form for the court.
Those have to be. Plea form indicates that the defendant is going to be pleading guilty to 2 charges, assault and battery and larceny. Those are added counts. Larceny under 200. Both 93-day offenses. Upon their successful plea to those charges, counts 1, 2, and 3 would be dismissed. There is an agreement between the parties of the prosecutor deferred sentencing. That's the court's full understanding. I don't know why the sentencing judge waiver is signed because I'm the sentencing judge. Is that your understanding?
Yes, it is.
Yes, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Tegan Donald.
All right, you can put your hand down. Ma'am, it is this court's understanding you're going to plead guilty to 2 charges. Is that your understanding?
Correct.
First charge is that of assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
The second charge is that of larceny under $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. That's greater than $500. That would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty
Yes.
to the charge of assault and battery? How do you plead?
Guilty.
To the charge of larceny under 200, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes, sir.
Do you have any questions regarding any of those rights?
I do not.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Understood.
You understand you're giving up your right to appeal of right.
Yes,
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of these offenses?
Yes, Your Honor.
On November 13, 2025, at the location of 1675 Cypress Point Court, Pittsfield Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty of the offense of assault and battery?
I made my mom feel threatened or unsafe at her home.
So you threatened your mother?
Yes.
In what way?
She was coming at me to prevent me from leaving the house. And I kind of physically stopped her from, I don't know how to explain it. I put my hands up and made her feel that I was coming at her.
That you were coming at her?
Yes.
As opposed, she was just trying to get you to stop you from leaving the house, but you came at her in an assaultive manner?
Yes. That's what it seemed like, yes.
Would that be the way to describe it?
Yes.
All right. And when you came at her, you did that on purpose?
Correct.
And you would agree that your actions reasonably or caused your mom to reasonably fear that you were going to batter her in some way or hit her?
Correct.
All right. And what happened with regard to the larceny under 200?
I took my mom's car keys from her.
Okay.
Yes.
Which was probably one of the reasons she didn't want you to leave.
Yeah.
Okay. So you took those car keys, didn't have her permission?
Correct.
It's not your car?
No.
You don't have any property interest in that car, is that correct?
Correct.
All right. Court does believe, based upon that there's a sufficient factual basis in which the court could determine a defendant's guilt of these offenses. Ma'am, I do have to apprise you, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under Michigan court rules, you would not be entitled to withdraw your plea, nor would the court be bound by any sentence evaluation or agreement. You understand that?
Understood.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And have I complied with the court?
Yes.
Yes.
Court will accept the defendant's pleas of guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
March 11th at 9 a.m.
March 11th, 2026, 9 a.m. before me. Bond will continue. Okay, thank you. Ma'am, you can stop at my probation department right down the hallway to start the process. All right, they'll be on your left-hand side.
Thank you very much.
Thank you.
Did the court want to address anything else, or we're good on the bond violation? I just don't want her to come back and have surprises.
That's fair.
I don't have a bond violation before me.
I had in my notes that they have ended or reflected bond violations, they may have the bond violation sentencing.
today.
If the court wants to adjourn it up in the same sentence.
I'm gonna do what I do. Thank you. So we will handle that at the time of sentencing.
Great.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Kent Robinson.
Michael Gaddy, Assistant Public Defender for Mr. Robinson.
Your name?
Ken Roberts.
Sign that. That's exactly.
What are we doing?
Your Honor, I've had a chance to speak with Mr. Robinson. We'd asked the court to allow him to waive his examination. I've gone over his right to an exam.
Sir?
Right here.
Is that what you're gonna do? You're gonna waive your right to a preliminary examination?
Yes.
All right. You understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
Or I'll let you finish signing. You go.
12.
People also waive their right.
Yes.
Your Honor, the people have agreed not to add any habituals.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts. Mr. Gaddy.
Your Honor, we'd waive reading and stand mute.
Defendant having waived from a reading standing mute. Court will enter a not guilty plea. Pretrial will be set for
February 26th at 1:30 with Judge Slay.
February 26, 2026, 1:30 before Judge Slay.
Thank you, Your Honor. If I could be heard on bond when the orders.
Go ahead.
Your Honor, Mr. Robinson is, I think he was arrested on a conditional bond violation. He does have a place to go. He was working snow removal, which is pretty busy this year for an outfit called Arnold Landscaping. He does have a local address he can go to that I can certainly give the court. It is living with family. He's not a flight risk in terms of leaving the area in any way, shape, or form. I'd ask the court to release him and consider if the court is concerned about his whereabouts or anything like that for a GPS tether.
Response from the people.
It's before, because I show 2023 operating in the high DAC, based on probation for January 21st. It just been off at the time. So a prior conviction in 2020 for carrying a concealed weapon, as well as drunk driving in 2017. Not in the CCA.
So he's got two prior weapons. Motion for bond reduction is denied. Bond will continue. Case People versus Wesley Edwards.
Andrew Childers on behalf of the people.
Leigh Gaines, Senior Assistant Public Defender representing Mr. Edwards, who should be appearing by Zoom.
Nope. I don't have him. You have him?
No.
It's not here.
Yeah, we were able to work out a plea agreement that he did sign. And so would Your Honor grant us an adjournment so we could try to get him here to court?
Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you.
Okay. Court calls case People versus Kimberly Robinson.
Veronica Glenn on behalf of Ms. Robinson. Can you please state your name for the record?
Kimberly Robinson.
Thank you. What are we doing?
Your Honor, we would like to she would like to waive her rights to a preliminary exam.
On both cases?
Yes.
All right. Is that a correct statement, ma'am?
Yes, Your Honor.
You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand that you'll not have that hearing, and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right, people also waive their right on both cases?
Yes.
Preliminary examination having been waived, defendant's bound over to circuit court on single count in each case. Your turn.
Thank you. I was waiting. Your Honor, we will waive formal reading of the information and we'd ask that you set this for pretrial.
Then having waived formal reading and your client does what? Stands mute?
Stands mute.
Defendant having waived formal reading and stating each of the charges, court will enter not guilty plea. Pretrial will be set for
February 23rd at 1:30 with Judge Hamoud.
February 23rd, 2026, 1:30, Judge Hamoud. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Amber Estelle.
Defendant not declare equitable, Your Honor. On behalf of Mr. Estelle, please approach you. Mrs. Estelle, state your name for the record.
Amber Estelle.
Estelle. Judge, we're asking for an adjournment. Ms. Estelle is hoping to get accepted into the treatment court in Hillsdale County. So if she's able to get into there, we'd like to see if we could attach this case to that. When is your next court date in Hillsdale?
You've seen the progress report?
I did, Your Honor. Yes, I have my notes for that. We did review it. I've spoken with her. She states that she spoke with Ms. Dozier last night. I think this came in earlier in the day yesterday. She has completed her intake with Hillsdale County. She's since taken 3 tests. They informed Ms. Dozier that they're supposed to be sending the results over to our community corrections.
She has since when taken 3 tests?
From, what is it, the February the 5th date? Is that what, when did you do the intake?
Last intake for Hillsdale County or here? Yes, it would have been Thursday. So Thursday, Friday, and then yesterday.
You
were on my
tested.
screens, yeah.
She says she's tested 3 times with Hillsdale County and they're supposed to be sending the results.
And what, we don't know the results of that?
She says that they're negative, except
Says
for
they're
the,
negative.
she does, but I don't have the results, obviously. She said that they've supposed to send it to Ms. Dozier. So if we can maybe pass, I can reach out to Ms. Dozier to see if she's received them.
And those are supposed to be all negative.
She says negative, except for Suboxone, which she has a prescription for.
And THC, because that takes more than 30 days to get out of your system. I've only been released for like a week.
Do you have a medical marijuana card?
No,
Are you still smoking marijuana?
no, but this would have been from prior because it takes like 3 to 4 weeks to get out of your system.
Right, but prior you didn't have a medical marijuana card either.
No, but it's illegal
Really?
in the state of Michigan.
Yeah, I'm shocked.
Okay.
Is that right? It's legal?
Yes,
Yeah.
yes, Judge, but she does understand while under bond conditions, she is not allowed to use any substance unless they have been prescribed.
But she has other cases pending outside of this one. And do those cases let her use THC?
No, Your Honor.
No?
I'd have to look at the.
So you've been on those cases for more than 30 days?
I have to
No,
look at the
sir.
dates, Your
No?
Honor.
No, sir, I got out on bond in Hillsdale County and got sent here and then got out on bond here and started my Hillsdale County. It was all within, it's only been 2 weeks.
The whole, all your charges have been 2 weeks
Yes, sir.
for the time of arraignment.
Yes, sir.
Are you just unlucky?
She's,
She may?
let me get my computer too, Judge.
Okay, you go ahead and do that. Yeah, tell marijuana is legal. Didn't know that. I'm kidding.
Next thing you'll tell me is sports gambling.
I just learned that they call those parlays, Judge. It's a new word.
Why are you gambling on sport?
I don't.
Okay, why are you
I don't have it.
parlaying?
I just learned the phrase and I hear it's a bad thing.
So why are you hanging around people that are parlaying?
You know,
I'm not saying they're not respectable. I just want.
I'm trying to be a good influence on people.
You're trying to what?
Be a good influence.
You are?
That's right.
Okay. As opposed to what you got in the past, right?
That's
okay.
Right. Hope for everybody to change.
Still waiting.
I'll just receive drug test results from Hillsdale District dated 2/5/2026 with a positive result for amphetamines, fentanyl, THC, methamphetamines. 2/6/2026 THC prescribed buprenorphine, 2/11/2026 THC prescribed buprenorphine. That was faxed yesterday to Ms. Dozier.
So her next one didn't show fentanyl.
Right. Yeah, the first one showed fentanyl, amphetamines, THC, and methamphetamines. On February 6th, the next day was a THC and buprenorphine, which Ms. Dozier notes prescribed buprenorphine. And the same on 2/11 THC and prescribed buprenorphine.
Got it. You just didn't know. Sometimes you're not good, you're just lucky. All right. So you want an adjournment?
Yes, you're right.
Grant the adjournment.
Thank you, Judge.
Probable cause will be adjourned March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank
That's
you.
March the 6th, right?
What did I just say? Do you have a calendar? Yeah, look, squint.
You're right.
Look at it.
You're right. Yep.
No, I know I'm right. I'm just saying you're not.
It's not the 6th, March the 5th. Wow.
Thank you.
Judge. I'm sorry.
Court calls the case, People versus Theophilus Smith.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who approaches Your Honor. Mr. Smith, can you please state your name for the record?
Theophilus Smith.
And Your Honor, we have submitted a competency finding on this matter. We stipulate to the finding of competency and we have no further discovery on that.
Anything from the people?
Nothing else.
The court would find that the defendant is competent to stand trial, specifically that the defendant can understand the nature of the objects of the proceedings against him and can rationally assist in his defense, therefore the defendant is deemed competent.
And Your Honor,
go ahead.
I am just asking for a 2-week adjournment in this as we work out our negotiations. And then I did also submit this morning an order for release to treatment. I did talk to Mr. Childers about that and he had no objection to that.
All right. So probable cause conference in these cases, I will set for February 26, 2026, 9 a.m. I will sign the order to release for treatment. I've done the order, the GPS order on that, so that he would have to have that prior to his release.
Understood, Your Honor. Thank you.
Okay.
Thank you very much.
Thank you, sir.
Yeah, you'll have to be on a GPS if you're released for treatment.
Court does call the case, People versus Matthew Fitzgerald.
People.
Yes. Fitzgerald, can you unmute?
Yeah. Can you hear me?
Yes, we can. State your name.
Matthew Fitzgerald.
Assistant Public Defender Ben Dunaway, on behalf of Mr. Fitzgerald, Your Honor, we would like to waive this preliminary exam.
Sir, you're waiving your right to have a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
I do.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
And can we just place on the record, he did waive up in exchange for the possession being reduced to a use. The reason to do the plea at circuit court is he's already on probation to Judge Conlon. So we'd like him to be on one probation.
That's all.
And we will stay in mute, waive the formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
Judge Conlon.
February 25th, 2026, 1:30 before Judge Conlon.
Thank you, Judge.
Bond will continue. Thank you, sir.
All right, have a good one.
That can go, Mr. I think it's in there. Court does call the case, People versus Kirby Snyder.
Glenn, on behalf of Ms. Snyder, can you please state your name for the record, please?
Kirby Snyder.
Thank you.
Your Honor, we would like to set this matter for a preliminary exam.
Questions to get some more information from her.
Discovery is complete.
Yes.
People have their witnesses available the 24th. Preliminary examination in these matters will be set February in person, February 24th, 2026, 9 a.m. before me, both matters. I did receive counsel approach.
Andrew Cooper, the attorney on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Freeman, who I believe is here by.
I think she's here, Richard. Ma'am, state your name, please, and get yourself someplace stable. Your name?
Deanna Freeman.
Deanna. An adjournment.
Yes, Your Honor, there's some investigation I need to have done.
Probable cause conference in this case will be adjourned March 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, ma'am. Court calls the case, People versus Derek White.
And then on behalf of the people.
Glenn, on behalf of Mr. White, can you say your name for the record, please?
Derek Sean White.
Thank you.
Your Honor, we would like to set this matter for a preliminary exam
Okay. Discovery is complete.
to the best of our knowledge.
People have their witnesses available the 24th. Preliminary examination in person, February 24th, 2026, 9 a.m. That's before me. Bond will continue.
Thank you.
Thank you, sir. Court calls the case People versus Dallas Fritz.
And then on behalf of people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Fritz, who appears via Zoom, Your Honor. Mr. Fritz, can you please state your name for the record? There.
You have him? Oh, there he is.
Hello, Dallas Fritz.
Thank you.
And Your Honor, I have just spoken with the prosecutor about this case, and we were just going to be requesting 2 weeks, as my understanding is that we should have an offer worked out by then.
Probable cause conference will be adjourned to February 26, 2026, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus Tenarius Williams. Harris. I think I got an extra I in there.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Williams.
Your name, sir?
Denard Williams.
What are we doing?
Your Honor, hopefully I submitted a green sheet. If I didn't, oh, yes, I'd ask the court to adjourn this. The people have given us some more discovery. I need to meet with Mr. Williams with my computer downstairs in the jail and go through it.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus, is it Laria, maybe? Grebo.
Morning, Your Honor. Raymond Cook.
Messing up your name all over the place. Come on up. Young lady.
Assistant Public Defender Ben Dunaway on Ms. Gribble, or on behalf of Ms. Gribble, who stands to my right, would you state your name for the record, please?
Larea Gribble.
Right. Just messing them up. All right.
Your Honor, positively speaking, we do have a resolution in this matter. I believe the plea form and the advice of rights and the police report have all been provided to the court.
I do. The plea form before the court indicates she's pleading no contest to the charge of embezzlement less than $200, a 93-day offense. Upon her successful no contest plea to that charge, count one would be dismissed. She agrees to pay $100 for restitution. That is the court's full understanding of the agreement.
That is correct, Your Honor.
That is correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Larea Gribble.
All right. Ma'am, it is this court's understanding you're going to plead no contest to the charge of embezzlement by an agent or trustee less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property embezzled or taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. The first is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes.
All right. Basis for the no contest plea?
Civil liability.
All right. So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
All right. Court has been provided and has reviewed Ann Arbor Police Department report. All that stuff. Get that. Ann Arbor Police Department report for their case number 25-47849. Any objection to the
Defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I would have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, ma'am?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from defense.
And have I complied with the court rules?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
March 3rd at 9 a.m.
March 3rd, 2026, 9 a.m. before Judge Garwood. Bond in this matter will continue. Thank you, ma'am.
Thank you, sir.
Court calls the case People versus Adashir Hassani.
Assistant Public Defender Ben Dunaway for Mr. Hassani, who is on Zoom.
Oh, there he is.
Hello, my name
Sir,
is
state your name, please.
My name is Ardashir Hassani.
All right. I have before me a plea form that indicates that the defendant would be pleading no contest to the charge of disorderly person. That is count 3, an added count 3. Upon the successful plea to that charge, counts 1 and 2 would be dismissed. The sentencing judge waiver was not checked, but he understands that I'm not going to be the sentencing judge. Is that correct, counsel?
That is correct, Your Honor.
Sir, please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name for the record.
Ardashir Hassani.
All right, you can put your hand down. Sir, it is this court's understanding you're going to plead no contest to the charge of disorderly person. That's a misdemeanor punishable by up to 90 days incarceration, a $500 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure that you understand. First of all, you understand that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And you understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, I do.
Still wish to plead no contest?
Yes, I do.
Basis for the no contest plea?
Civil liability.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind?
Yes, I do.
All right. You signed an advice of rights?
So if we haven't put the warrant in the lien yet, Heather, don't. Good morning, Mr. Longton, or afternoon. Your appearance?
I'll call out your honor, so.
Your name, ma'am?
Sorry, else.
There's a multitude of probation violations or bond condition violations that are alleged. February 8th, all day on the 9th. I'll be happy to give these to you. So the 10th, all day from 11:27, the 11th. So I'm going to hand you this, Mr. Longton. You can look at it. I'm going to conduct a hearing. She can either plead guilty or we can have a hearing as to whether or not she violated the bond conditions. So we'll go off the record. I'll let you two talk and.
Not necessary.
Okay.
I already discussed this with her and plead not guilty. I explained to the court why.
No, that's okay. We'll have a hearing right now.
Right.
But I'm gonna, Ms. Wild, your name?
Elizabeth West Fisher.
Okay, so Mr. Longton's advised that she is going to plead not guilty. So are you ready to proceed with the hearing?
I am, Your Honor, as well as the SoberLink expert with house arrest services. I told him that if he was needed, I would be able to email or call him, and he would be happy to be here present as well.
She still wants us to do that? If she does, that's fine.
She does.
Okay, call and get them ready, and then we'll start the hearing. Why don't you make an extra copy of that?
I did, just to be on the safe
So
side.
I'll take the one, the original there that I gave to Mr. Longton. And we'll go off the record while you call them.
I called her.
I'm recalling Summer Grade House. Mr. Longton's here, Ms. Wiles is here, and Ms. Greathouse is here. So they're pleading not, she's pleading not guilty. You can start your testimony. I understand house arrest is going to be zooming in any second, but I'll go ahead and we can start. And then Mr. Longton will have an opportunity to question you. Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth to help you God?
I do.
Okay.
Sure. On February 5th, Ms. Greathouse was referred to house arrest services to obtain her SoberLink device, which she did do in a timely fashion. I was notified on February 8th that Ms. Greathouse was positive for alcohol at 7:27 p.m.
Yeah.
with a 0.019%.
Wait 1 second. He just told me house arrest is out there. We'll bring it. All right. House arrest services. You can start your video, unmute, and state your name, please. There you go. Thank you. Your name?
Yes. Hi, my name is James Hunt.
Okay. The probation director is just beginning her testimony, so we're going to let her conclude, and then we'll go from there. Thank you. Go ahead.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greathouse was ordered to obtain the SoberLink, which she did. I received an email February 8th indicating that Ms. Greathouse was positive for alcohol, 7:27 p.m. at 0.019%. For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that counsel has been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Miss Greathouse was positive at a 0.029%. She called house arrest services claiming this was due to brushing her teeth. House arrest services did inform her to continue to blow as required. So at 11:17, she was and this is a typo on my part, that was 0.023% at 11:17 a.m. Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 3:44 at 0.013, under that cutoff, no further blows required, continued to be positive that day, 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff, continued to be positive that day at 11:22 p.m. at 0.025%, and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did continue to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%. And at 11 p.m., she did fail to blow. An hour and 55 minutes later at 12:55 a.m., she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call house arrest services, and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House arrest services did inform her that as long as it told her to reblow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear. But the one excuse that Ms. Greathouse used about brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them that indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Ms. Greathouse continuing to blow, but again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol that she had to continue to blow, Your Honor.
Okay. Do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify reliable as device is, correct?
I would leave that up to Mr. Hunt, sir.
The answer is no. You're not totally qualified.
Okay.
My questions are Mr. Hunt.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Do you want to ask him some questions?
I'm going to ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greathouse in reference to the possibility of that device being defective. And you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking. Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hahn. When my client calls Silverland to complain about the device, did she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Miss Hall, one of our monitoring room employees.
And that note says what?
That she called and stated the device keeps telling her to take multiple, to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other notes?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Ms. Greathouse.
Isn't it true that these devices sometimes fail before reading 1,500 tests?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
you don't?
No, I do not. No.
Your Honor, nothing further than this call.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? That the manufacturer can tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, guys, this is just totally across it down.
Wait a minute. I want to interject.
I wasn't done.
Yeah, let her finish first. Go ahead. You want to ask a question?
Yeah, I had a follow-up question to that, but Mr. Longton chimed in. Mr. Hunt, and it actually alluded to what Mr. Longton was. So if we send that device in and the manufacturer reviews the device and we get that report back, that then piggybacking off Mr. Longton's question, then being the expert because that is their device, would we know if it malfunctioned or not?
Yes, correct.
Thank you. And I am done now.
And read the conclusion that he drew in the email again. Will you do that for me, please?
I can actually read that in whole. Says, good morning, Ms. Wilds. As we discussed on the phone, I went ahead and did some math to figure elimination rates. And these events are consistent with consumption. I have a consolidated report attached, and I also have a detailed report covering her positive dates from 2/9 to today. Knee-jerk reaction, seeing the mix of positive and compliant, was device failure, but looking at each as a single event, these are consistent with drinking. If you have any questions, please let me know. And it is signed by Mr. Hunt.
All right. Do you have other questions?
I have none. I had my comment. That's it.
Okay. Raise your right hand, ma'am. You solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Okay, go ahead.
So what happened during the earliest possible?
I'm sorry, I didn't hear the question.
What happened with sobriety starting with these early possible days like February? What happened?
On the night, so I had taken a couple of days off since the last time I was in court and I stayed home. And then I went back to work that Tuesday, I believe, and I'm in my car a lot. So when I left this morning,
Wait a minute. Which morning are you talking about?
the 9th, I believe that was Tuesday.
Well, the first one said she was positive for alcohol at 7:27 PM on February 8th.
So talk about February
8th. What day of the week was that?
February 8th would have been a Sunday.
Honestly, Sunday I was at home with my kids. We played some games, had the football game on. I got them to bed because I had school the next day. And then, so it must have been Monday then.
February 8th is Sunday.
Okay, so then starting that Monday, I had gone back to work, back into the office, driving around throughout the
So the
day.
question is, what happened on February 8th at 7:27 PM?
No idea. You know, I didn't ask, I don't remember that it asked me to retest. Honestly, that was on Sunday. I don't remember.
Go ahead. On the 9th, you went to work. What time did you go to work?
I left my house at about 10:45.
Okay, where do you work at?
The office is in Allen Park, but I drive clients around or meet them at different houses. I do real estate.
Okay, so
So on Monday, I had a client that, well, I went to the office first. We had an 11 o'clock Zoom. I did the Zoom and then I left. I met up with the client, so I did a bit of driving around. When I had gotten the first one, I brushed my teeth, left the house. I do smoke cigarettes. So when I called, I didn't claim that it was because of brushing my teeth. From my recollection, that was the first time it had asked me to retest. So when it happened, I called right away and asked about it. I called house arrest. And I said, this is asking me to retest. And so I had asked questions the day when I signed the paperwork, when I got the device, and like Ms. Wilds had explained, like they did kind of go over everything. That was the day that I was in court. Did I necessarily remember the 15 minutes before and all of that stuff? No, yes, I did sign it. There was a lot going on. It was high stress, high anxiety. She went over it.
Let's keep.
Okay, so this day, all day I was driving around clients and I picked my kids up at this 3:26 time. I was with my kids. We went home, we had dinner. That was on Monday. They didn't have any sports that evening.
When is the last time you consumed heavy coffee? Is it before February 8th, 26?
It was. Yes, it was in December.
Last time you consumed alcohol?
Yes, sir.
Did you consume alcohol on February 9th any time?
No, sir.
So on your device, when you blew at 3:26 and 3:44, did you see these readings on your device?
No, sir.
You don't see these readings?
No, sir.
They don't. And okay, so you just
Says
said
to
it.
retest. No, sir.
And when you're asked to reblow,
Yes, sir.
when were you asked to reblow?
Tells you to wait 15 minutes.
Right, so on February 9th, how many times were you asked to reblow?
The 9th. Felt like every time I did it, that's why I called. And then I wasn't asked to reblow on the 10th in the morning. and I
Let's stick
think-
with the 9th.
Okay, so every time, and I had called that day and I called house arrest. And I said, it keeps asking me to reblow. What could the reason be? She said I could bring it in and have it recalibrated. And then I had.
Did you, okay, go ahead. I'm sorry.
So then the next test, I believe, did not ask me to reblow. And then the one in the evening, I think did ask me to reblow. And then the next day, it didn't in the morning, and then it did a couple of times throughout the day. I think that one was the day that it asked me multiple times, or maybe not.
Let me ask you a question.
Yes, sir.
I ordered you to go and get the sober link the day you were in court. That's February 5th, right?
Yes, sir.
Did you go on the 5th?
Yes, sir.
Did you have any problems when you blew into the machine on the 5th after you acquired?
The first machine they gave me was not working, so she gave me a second one, and then no.
Before you left?
No,
Wait a minute, slow down. Let's slow down. You went over to house arrest on the 5th
yes, sir.
in Livonia.
Warren, it's Warren.
Warren, I'm sorry. Warren,
Yes, sir.
you said she replaced the machine?
The first one she gave me was not working.
And did she replace the machine before you left house arrest?
Yes, sir.
Okay, so you went back from house arrest on the 5th, right? With a workable machine, at least in your mind.
Yes, sir.
Did you have any problem when you blew in that machine on the 5th?
No, not good.
Did you have any problem when you blew in that machine on the 6th?
On this, I don't remember if it was.
Well, let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th.
Yes, sir.
You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish. You didn't have any positive blows on that machine on the 7th, did you?
No, sir.
And when you woke up in the morning, when is the first time you tested on the 8th?
Would have been between 6:45 and 7.
Did you have any positive blow on that time, on that occasion? Well, any problem with the machine testing inappropriately until at least 11 o'clock on or about the 9th of February.
There was the 8th.
Okay, you're right.
The only issue.
Wait a minute, slow down, my mistake. On the 8th, you blew positive at 7:27 PM, right?
Yes.
How many times did you test it on the 8th prior to the 7:27 positive blow?
I tested 3 times.
Any problems with those results when you blew on the 8th prior to the 7:27
No, sir.
blow? Any problem with the machine when you blew on the 7th?
Not with a retest. The only issue I had with the machine that Saturday was that it wasn't turning on. And when it finally did power on, it had battery. So it wasn't that the battery was dead. That was kind of when it's. I didn't think much of it.
Any positive blow on the 7th? I'm asking you.
Oh, no.
Any positive blow on the 6th? Okay. Anybody have any other questions on it? Go ahead.
Your testimony been completely candid.
You got to keep your voice up for me, though.
Up.
Yes.
When you hear it, has your testimony been completely candid?
Yes, sir.
Last time you had a drink was in December.
Yes, sir.
You willing to take the polygraph?
Yeah, we did.
They're much more reliable than they were when you and I started practice law. And Taylor Police Department has a polygraph, and they're more than happy to pay for the polygraph. Because otherwise, you're going to make a decision based on a device that could well be defective.
It could be, and if I am not satisfied by preponderance of the evidence that she consumed alcohol, I'm going to find her not guilty. No, wait, just wait. Let's not, I don't want to talk about polygraphs. You ask your next question. Mr. Hunt, I want to ask you one while he's thinking.
Yes, Your Honor.
I want to make sure I understand. You said maybe every 1,500 blows, it has to be recalibrated. Right?
After 1,500 blows, yes, it's due for
You said
recalibration.
this particular machine, based on your inspection, still had roughly, I think you said, I want to double check, 1,444 blows.
1448.
1,448 blows until the machine needed to be recalibrated.
Correct, yes.
Go ahead.
Mr. Hunt,
Yes.
last year, 2025, were there machinery that turned out to be defective before there were 1,500 blows?
I'm sorry, can you say that again?
Last year, January through December of 2025, were there devices that turned out to be defective and needed calibration before 1,500 blows?
Yeah, it's technology. Things can fail. That's absolutely true.
And you had devices that did fit, correct?
Yes.
DNA open today?
But on-site is, yeah.
Good.
Yeah.
What else?
Your Honor, I have the greatest confidence in my client that she's telling me the absolute truth. I think it would be her horrendous miscarriage of justice to have her guilt based on what you've heard today from both her and Mr. Hunt. And I know you don't want to hear anything about polygraphs. I understand why the District Court of Appeals is clear about that. But in all honesty, when you and I practiced law, they were only 60% effective. Today, they're 98% effective. I'm more than happy to have her polygraph. That's a tailored PT.
How do you explain the fact that this machine was working on the 5th, was working on the 6th, was working on the 7th, and worked until 7/28 or 27 properly on the 8th, and then all of a sudden she starts blowing positive, and now there's a problem with the machine?
And we don't have the testimony from the factory to answer that question as to whether it worked properly today, failed tomorrow, and worked properly 2 days later. We don't have that kind of technical testimony. Mr. Hunt's already testified he relies on the factory for that kind of. When I told my car this afternoon to come here, my brand new Jeep would not start. I had to go back in, call the dealer, come back out. Eventually, it started. Who knows why? They don't know why. Who knows why, whether or not this thing fails every other day or failed all these times? We don't have the technical testimony from the factory. I don't have it.
I don't, you know, this is not, we deal with these machines all the time, Mr. Longton. SoberLink devices are accurate. Once out of every 500 defendants will somehow, some way, when they get results like this, want to try to insist that there's something wrong with the machine. There's nothing wrong with this machine. They don't need to prove beyond a shadow of any doubt that the machine is working accurately. It's pretty evident here. He told you what it needs to have to recalibrate, or how often it needs to be recalibrated. He said it still had 1,448 blows left. It's clear it was working on the 5th, the 6th, the 7th. And based on these results, when you take them, I've got testimony from Mr. Hunt that it's consistent that the amounts would reduce like this. Yes, listen. I don't think there's any question in my mind that she was drinking. Okay? I get this all the time. And there's no question in my mind that she was drinking. And I'm not going to order a polygraph. I'm not sure I don't want to send her for a test. But I'll tell you what, I'll send her for a test.
If she flunks, put her in jail. Because I'm confident she's not drinking.
If she flunks on this test, I will put her in jail and she will remain in jail. I will set a bond she won't be able to set because I've just then, in my view, as I believe now, I've had somebody commit perjury in this courthouse, and I don't think very kindly of that. So yes, let's have her go to on-site today.
Yes.
Now, I am not going to be here tomorrow, but I will be more than willing to Zoom tomorrow. And we can Zoom on this case at 9:30 in the morning or 10 o'clock in the morning. You available, Mr. Longton?
I will change my schedule.
We'll Zoom on this case at 10 o'clock.
What I could do is I can have them send it straight to the lab. It won't be a screen, which would probably be more preferable. I assume Mr. Longton would prefer that as well, since he wants the actual results. So she can submit to her test today at 4 p.m. on site, and they can actually send it to the lab. Now, those results won't be back tomorrow. Should be back Monday or Tuesday. Court's closed
What
Monday.
does trouble me though is, yeah, let's do that. I'll do that. We'll continue the hearing at 10 o'clock. Now, I'm going to give you one last opportunity.
Yes.
I'm gonna let you go test. If that test comes back positive, as opposed to me finding you guilty right now, I'm gonna set a bond you will not be able to make. Do we understand? Maybe you need to go confer with your lawyer. I've been doing this a long time, young lady. I can tell who's telling me the truth or not. I don't pretend to have every answer, but I'll tell you what, I'll compare my ability to determine somebody's credibility with anybody's. And I don't believe for 1/2 a second that you're telling me the truth. And then if you go and test and I have confirmation that you've committed perjury in here, you're going to have a massive problem with me. It's going to be so big of a problem, you're not going to want to, you're not going to believe how bad it's going to be. So I think before I send you for that test at on-site, you need to go confer with your lawyer for a few minutes. And after you confer with your lawyer for a few minutes, if you two want me to still order you to go to on-site, I'll order you to go to on-site. But do this, listen, don't talk to him now in front of me. Go take a few minutes, but think very carefully about what you're about to get into, okay? Do we fully understand one another? Okay, all right, you guys go talk. We can reconvene in here in a few minutes. Thank you.
Are we all set with Mr. Hunt, Judge?
Mr. Hunt, unless we call you again, thank you very much for your testimony. Mr. Longton, do you need any more?
Of course.
From Mr. Hunt?
Your Honor, I only have one question.
Well, I'll tell you what, you go talk to your client and he'll come back in here. Will you Zoom back in at 1 o'clock and we'll reconvene at 1?
I sure can. Absolutely.
Perfect. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Calling Summer Lori Greathouse, 25F245-336.
Hold on, Your Honor, but Your Honor, I'm gonna ask you what the last time she had it on. She excluded the fact that she's been drinking non-alcoholic beer and thing. And my question for Mr. Hunt would be, would that create a positive test? I don't think it would, if manufacturer's representation as the containers is accurate. It's almost 0% alcohol, but I don't know.
We're just gonna follow this little circle around. We're gonna follow the circle around. I just want to know, does she want to get tested?
Yeah.
If she does at 4 o'clock, I'm sending for a test, and we are going to reconvene here at 9:30 or 10 in the morning. If she doesn't, sounds like she's already changing her story. I didn't hear one thing about a non-alcoholic beer until you just mentioned it. Not one, not even close. There's no remote reference to a non-alcoholic beer. So this is what I'm trying to tell you. I don't want to sound like a know-it-all, but I've seen this movie. I've seen this movie thousands of times. And if she wants to go for a test, I don't mind sending her for a test. But I don't hear this nonsense about non-alcoholic beer. Now I'm hearing, Ms. Wiles, you're just walking in, about she's drank some non-alcoholic beer, and would it be positive? So I want Mr. Hunt. I asked Mr. Hunt to show up here at 1 o'clock. And I'm hoping he's going to log in now. Do you see anybody from house arrest out there, Heather?
I do not, Judge.
Give your phone, Beth.
I do not, I'm typically the one with vehicle.
So, I just see this perpetual denial. You know,
There is an alternative. That is that she's correct. And
there is an alternative, like there's an alternative that I could pogo stick to the moon too right now. I mean, there's a possibility that some Martian could come grab me. I mean, look, it's fine. We'll send you for the test. I'm only telling you, I have one set of bond in mind. If I don't think that you perjured yourself. And I have another set of bond in mind if I do think you perjured yourself. Okay? And if I send you for a test and it confirms this on top of what I have, I will be 1000% convinced that you perjured yourself. In which case, I'm going to set the bond that I would set if I'm convinced that you perjured yourself. I don't have any problem with you going for a test. You want to go for the test? You go for the test at 4 o'clock. We'll reconvene here at 9:30 or 10. Mr. Hunt, you know, I told him one, I didn't want to have to wait.
Your Honor, may I have another moment with my phone?
Yeah, you can have another moment, but
Your Honor, you've been very clear. So allow me.
I know. I'd like to think I'm clear. Do I have this other person's file here, Heather, this gentleman that just came down?
Yes, she just brought him down.
Come on up here, sir. People against Kevin James LeBeau. 26W841086A and B. How you doing, Mr. LeBeau?
I'm okay. How are you?
Your name?
My name is Kevin James LeBeau.
What do you need? Time to pay?
Yes.
Okay. How much do you have today?
Today I have a total of $400 to my name, but I'm behind on a lot of my bills.
Do you work?
Yes, I do DoorDash, but I also do all the driving and guarding care of my mom, who was diagnosed with early stage dementia last February. But
okay, let's slow down.
Sorry.
I'm going to help you. Okay. At least you have the courtesy and respect enough to come in here. You owe $165 on file A. Listen to me. I will reduce that and charge you $110 right now, and you can be done with that ticket. Is that fair?
Yes, sir.
Are you sure?
Yes.
Okay. Now you got another ticket of $215.
Yes.
I can reduce this one for you to $150 and waive the balance if you can pay it today. Otherwise, if I'm going to set up a payment plan, I got to have you pay the whole thing.
I'll pay it today, sir.
Good enough. So see,
So much.
you pay $110 and you pay $150 on the other one. Balance is waived. And you're all set. I wish you would. You're welcome. Good luck. You have a valid plate now, right?
I'm trying to get it.
You got to get insurance in a plate, sir.
I know I'm trying to get it. I came down here to figure out these fees.
You're all set. Go down the hall. Fix your date. Good luck. Thank you.
No.
I do not. My numbers are, he's in Florida, Your Honor.
Well, he's the smart one. Would you do a favor and call over?
There is.
We. Nice.
Yeah.
Nice.
Lots of
Yeah,
golf.
this has been a brutal winter.
Oh, it's came this way too. We got 8 inches of snow a couple weeks ago, so it was
It's
pretty wild.
crazy.
Yeah, yeah.
Guys. Yeah. Feels awkward.
Keep that awkward silence.
Oh. They're probably just talking.
Like a new board on your phone. It's really hard, like it's static.
It's the phone.
Is it the
I think
phone?
it's the phone. He changed the cord.
Sometimes it doesn't even work. It's hard to hear
I
you.
know.
You sound like you're.
Ever since they switched to the new phones, remember the old phones we used to have? When they went to the new phones, everybody got called from this phone, can't hear.
Recalling Summer, we were back on record, right? Summer Lori Greathouse, 25F 245 336. Okay, everybody's name again. Your name again.
Oh, yeah. So
Ma'am, your name.
Summer Great House. Elizabeth Fospation, your house.
Mr. Hunt. Your name again, Mr. Hunt?
James Hunt.
All right, what is she want to go through the test or what?
Yeah, can I ask Mr. Hunt just one question?
Sure.
Mr. Hunt,
Yes.
do you have knowledge that the device can malfunction one day and function normally the next day? Is that possible?
I have not seen that in my experience. No.
So you're right, we're gonna change our.
I don't want her to sit here now.
I'm sorry.
So just so you know, I'm gonna make the decision because I'm gonna spare her the disgrace of just admitting to me under oath that she has committed perjury. I mean, I will do that if you want it. I don't want her to plead guilty now when she just testified under oath that she hadn't consumed anything until she came back and said it was non-alcoholic beverage. So if you're telling me she's not going to go for the test, I'm simply going to make my finding right now. And there's no reason for her to change her plea because honestly, I think it's horrible if I'm going to sit here and have somebody admit that they just committed perjury in front of me. So that's what I'm suggesting to you. If you want a different route, you can do that. I get it, Mr. Longton. But I still think, even though I'm upset that somebody would do such a thing, I still have a function here and I'm going to do it to the best of my ability. And that would be my advice to your client. But that's not, she need not take advice from me. So if she wants to just say, If you want to tell me, Judge, we don't see a necessity to go for the test at 4, then I will simply make the findings based on what I've heard here, testimony from your client, from Mr. Hunt, and from Ms. Wiles.
That would be a correct term.
Okay.
She will not continue.
Okay, so I'm gonna simply, I'll listen to argument if you want. Do you want to argue or you want me to just make my findings here?
You're fine.
The court finds that the machine was properly working, that the defendant consumed alcohol, and that the document, which Ms. Wild signed February 12, 2026, evidences that intent, or evidences the results. And also, I'm going to find you guilty as charged. Now, you and I are going to have a conversation, young lady. You should have been charged with a felony. You should have been charged with a felony. Now, I don't know why they didn't charge you with a felony. I don't know. I don't care. It's not my business. I just do what they put here in terms of files. Now, in my view, you needed sobriety, because I still think we can help you. But if you come in here and you lie to me, there is no way in hell I'm taking you in sobriety court. Excuse my language. I should not have said that word. Ma'am, don't say anything. You should not be saying anything. You are the whopping old age of 38? And this is now your 4th offense. And judges don't like this when you have 4 offenses by the time you're 38. They should have, like I said, charged you with a felony. I'm not being punitive when I do what I'm going to do here, but you're scaring the devil out of me right now, because when you have a judge tell you not to drink and you've had 3 offenses and you've had a SoberLink device, and then you come in and you tell him under oath that you didn't drink alcohol and he knows that you're lying, I can't help cure somebody who is not going to admit that they are drinking. I get it, that they have an alcohol problem. I get it. There's a form and an element of denial. But honestly and truly, you are going to live a short life if you don't get off of this stuff. It's your life. It's not mine. I have no choice here but to forfeit your bond. I am forfeiting the bond. That means you're losing your $500, and it also means you're going to have to post. And it's a good thing that you guys didn't go for the test just to verify what I was listen to me. What I was 100% sure of, and that is that you had consumed alcohol. I'm forfeiting that bond. I made a mistake when I only gave you a $5,000 bond. Ma'am, I'm going to explain it to you. I gave you a 5,000 10% bond. You know why? Because you told me, as I recall it, you only made about 50,000. Well, that's why I gave 5,000 10%. Because I thought, well, I got to run a SoberLink. She's had 3 priors. Maybe she'll understand that this judge is a little bit serious, but I still cut you a break. And now you go out and you drink again, and you come in here and tell me what I know are lies. 60,000 10% is the best I'm doing. 60,000 10%. You're going to have to post $6,000 to secure your release. I have a pretrial date. Make sure any warrant that was entered is canceled. And
If you have until tomorrow.
I'm sorry, Mr. Longton.
There's no way.
There's no way in heck I'm letting her out. She scares me.
Listen.
Ma'am.
Your Honor,
Ma'am, no, I have made my decision. Listen to me. You are not taking this seriously. You are not. Ma'am, you will not hear me change my mind. I don't decide things over a bowl of Cheerios. I knew if we had a hearing today, you were going to at least have this, because I was sure you were drinking. When I talked to you and saw you under oath, you're making your own bed. This is like going to Maui compared to what's going to happen if they turn around and charge you as a felon. I'm telling you, I'm not arguing with you. They'll let you make a couple of calls. I'll move the pretrial date if you want, Mr. Can we do this earlier if she can't post the bond, Miss Heather?
Let me take a look, Judge. The
I'm
Flat
sorry?
Rock case,
Yeah, it's just Flat Rock. I set it for March the 3rd.
next that we have Flat Rock is next Thursday, the 19th.
I can do the 19th.
We have Flat Rock is next Thursday, the 19th.
I can do the 19th.